Yes. You see it right.
Good morning.
Morning, how are you?
Good, how are you?
All right. Why don't we get started? It is Tuesday, the 8th. And we've got a plea and arraignment calendar this morning, plus it's got a bonus probation revocation for Mr. Taylor. And we do have one defendant on the plea and arraignment who I think will be patching in from a facility in Gwinnett. That's not the Gwinnett County Jail, who may need an interpreter, but we're not sure. And it will be with Ms. Cabrera, but she's not on yet. So once that person appears on the screen, if he does, that's position 5, then we'll take care of it. Word on the street is that he won't need an interpreter, but I'll believe that more if and when we connect with him. So thanks for waiting.
Now, do you have a bond here for presiding?
So
Also?
maybe I'm not presiding,
No,
but
it was from before, he had his prelim and we switched it out.
is this Jeremiah Oliver?
Yes, sir. You
Okay, he's on the calendar. And it's a PI, so I guess that would be on for bond.
Yes, sir. That's all.
Hopefully, Ms. Dilligard's ready to roll with that, or she'll get Mr. Abate or someone in. But we'll get to that. That's number 14. All right, position 1 is Ronald Lawson. Good morning, Mr. Lawson. Let me get your case up on the screen here. Whoops, wrong buttons. You were transferred to us from non-complex. All right. Who is handling Mr. Lawson's case, Ms. Rios?
Do you mind? I have not had contact information, so I'm going to talk to him and get his contact information and discuss the waiver.
Got it. So, Mr. Lawson, Ms. Rios is going to introduce herself to you when we get through the calendar. She's going to need to get good info. If your address is not on Holly Street, we'll need to get a new address. We'll fill that form out. You'll want to give your phone number to Ms. Rios. She'll give you hers. But the fact that you knew to be here today says to me, maybe stuff is going through the mail and getting to you. Good. Then Ms. Rios will talk with you, and then we'll talk one more time after she's had a chance to talk with you. All we're doing today is handling arraignment. If Ms. Rios and you decide to waive arraignment, that just means I don't have to read you what your charges are. And then we'll get a scheduling order in place. And as long as we've got good contact information for you, you'll know when you need to be in court again. But we'll talk again later this morning. Thanks for being here. Marquise Sinkfield.
Your Honor, he would be mine. I have not been able to get in contact with him.
All right. We'll call him one more time at the end. Otherwise, that'll be a bench warrant. Jamal Nollie. So the transfer, non-complex is working hard on that stuff. If it's a transfer, they should have seen him. Let's see. Yeah, he had final plea earlier this month. So They have been in touch with him. Mr. Nollie would be whose case, Ms. Rios?
Ms. Wood.
Okay, I think she's on our call. There she is. Hey, Ms. Wood.
Morning, Judge. Yes, if he shows up, I will need to get new contact information from him.
All right. Elton Taylor should be in custody. He's got a new case, ours, and 3 old cases, ours for purposes of probation revocation.
That's one of those, it's shown.
Well, they're all elsewhere. One is Judge Cox's case, one is Judge Barwick's case, but because the basis for the revocation is this shoplifting case, which is not new. It's from October 2023, but it was recently indicted. This is where we would handle the revocations per our special policy that is confusing. But it's in the right place. So who has Mr. Elton?
He's mine, Judge.
Me, Mr. Taylor.
Yes, Mr. Taylor's mine. Was he brought to the building or is he gonna be on Zoom? I know he was housed at Oconee.
He's here.
Okay, I'm gonna walk down after the call of the calendar.
Great. Maybe we can deal with everything. Who knows?
Yes, sir.
But he's got 3 revocations and this new case, and the new case is the primary basis for their technical, but this is the main basis from almost 2 years ago. All right, position 5 is the gentleman who is in Gwinnett, Mr. Hernandez. And I think Ms. Cabrera will be handling that, but we don't have client or lawyer. So we'll hold off on that. Miguel Cargill. Shannon Guest, would that be your office?
Yes,
Is-
Your Honor. I believe this would be Ms. Wood's case.
Yes, that's correct, Judge. And it looks like whichever one of these was the more recent arrest, it was dismissed at prelims. So, and I have some notes. I think he may be unhoused.
Okay. All right. He's 2 positions in a row. All right, well, I'll call the calendar again. If he makes it, great. Otherwise, we'll do a bench warrant.
Thank you.
Ulysses Greer. Good morning, Mr. Greer. Mr. Greer is here. Whose case is that?
This is a conflict case, Judge.
Oh, okay. Ms. Nelson, do you know if this is going to be Ms. Cabrera? We'll work on
No,
that. So-
Judge, I do not know. I'll check with her though.
Okay, thanks. So, Mr. Greer, I need you to sit tight. We're gonna figure out who, you plan on hiring a lawyer? You don't need to. I'm just wondering if that was something you were contemplating. Well, it's more a question of whether you've got the ability to. You've got the right to, but if you don't have that kind of money sitting around, then you're entitled to a lawyer, and I'll get one appointed to represent you. You always, partway down the road, could switch if you get the funds to hire someone. But we need to move. Your case is old. It's a new indictment, but you were arrested back in December of 23. So we want to keep this moving. So we'll figure out who your appointed lawyer is. And like I said, if you choose to switch it up because you come into some money, you can do that. But if you'll take a seat, we'll figure out if we can get Ms. Cabrera, who would be the lawyer likely appointed to you, okay? You sure can. Just come on back. All right. Isabel Hicks. This doesn't have anything about a bond or whatever. I'm wondering if it was a direct indictment.
She'll be mine, Judge, if she shows up. The numbers I have for her did not work.
No, it just looks like she posted bond early on and then, so she has a bond. Okay. Isabel Hicks. from Portsmouth, Virginia is the address in the system, so we'll see what happens. All right, Lasana Pitts. Hello, Ms. Pitts. Good morning.
Be mine, Lorna, I just need to talk to her, members of the system.
Okay. Ms. Rios will talk with you, Ms. Pitts, and then you and Ms. Rios and I will talk and we'll get you on your way. Thanks. Kalen Aiken.
Jay. He is mine, I did file a waiver.
Oh.
And, you just need to, you can just bring him out, I already talked to him, and refer him to drug court. And
Oh, he's here.
Yeah.
Okay. All right, so you've done a waiver, but we should still say hi.
Mhm.
Okay, and you're hoping he can get into drug court.
Yes, he's already been interviewed, they're just waiting for his medicals, and I briefly talked to Ms. Dillard about it.
Okay, great. Would this be a diversionary drug court or a plea drug court? A plea drug court. Okay, well, let's see if he gets in. Robert Brown.
Judge, he'll be mine if he shows up. I don't know if we'll see him. It looks like there's an active warrant for Mr. Brown.
Okay. This is a low yield calendar. Yeah, he was arrested very recently, bonded out pretty quickly, and I guess is not around. How about Jessica Jenkins?
Judge, she's got a private attorney. He filed a waiver, not the waiver that we use, but there was a waiver in the system.
Is that Mr. Smith? That's the lawyer?
Yes, Judge.
Yeah, he did. Okay. Ms. Nelson, did you have any contact with Attorney Smith about Ms. Jenkins not being here?
Yes, Judge, parties are excused. I'm sorry.
That's okay. All right, so then we just need to do a scheduling order. Waive and schedule. Okay. Jeremiah Oliver. Oh, that's Ms. Clark's client. He's here, and that's going to be a bond hearing.
Yeah, and Mr. Rice is on his way up.
Okay. Elton Taylor. Oh, this is part of his probation revocation, so that's the same guy. So that's the calendar. Anyone here who didn't hear their name called? You're Mr. Sinkfield. And a Steelers fan, or that's just the best hoodie you could find? That's all right. Thanks for joining us. Was this your case, Ms. Rios?
Yes, Your Honor, I just need to talk to him.
All right. Mr. Sinkfield, Ms. Rios is going to talk to you, and then the three of us will talk once she's done that. Today's just arraignment day. We're figuring out if we've got good contact information. Ms. Rios, I assume will enter a not guilty plea on your part, and we'll go from there. But you two need to talk before we have that conversation. All right? All right. Anyone else? Okay. Then why don't we have the lawyers talk with clients? We can do the bond hearing when Mr. Abate gets here. I'm gonna go back and work. Oh, here he is. All right.
Attorney. Judge. I'm gonna drop off and I'll be at the courthouse in a few minutes.
Okay, we'll see you soon.
Thank you.
Something in Teams. Okay. So. Mr. Greer, we are gonna need to reset your case because the lawyer who I thought was gonna represent you is not. I don't want to make you wait around, but I do want to make sure we've got good contact information for you. So first, is the 901 Gaston, that's a good address? What's there? Is that a house, an apartment? Whose house? Your grandmother's? Okay, and you get mail there? Okay. I need you, Deputy Gordon's gonna give you a note card or something. I need you to write down a phone number. That's a good phone number for you. If you got an email address, put that on there as well. And we'll get that to the lawyer who's appointed to represent you, so that he or she can contact you to say, hey, I'm the lawyer and come on down to court. And then we'll get you a new court date. I need you to write down your phone number and an email address if you've got an email address. I'll tell you the other stuff again after you've done that. So Mr. Greer, we're going to figure out who your lawyer is. That lawyer is going to contact you at this, assuming I can read it. Yeah, so one of the phone numbers is a 943 area code. Where's that? Okay, but that's one of them. And the other is a 404? Got it. Your uncle's here? Oh, hello, uncle. All right. And it's a Yahoo. Got it. Okay. So we'll figure out who the lawyer is. You'll get notice in the mail of when you need to come back. And you two can meet and we will try to move your case forward. Any questions? You know what your you understand why you're here, what the case is, or? Yeah, I mean, it's from December of 23. It's an allegation of aggravated assault. And we're not going to talk about the case, but just to orient you. It's supposedly something that happened between you and a Darian Harris back in December of 23. And one last thing, let's make sure your bond order, you are supposed to stay away from Darian Harris. And as long as you're not talking about the case, yeah. You said I'm supposed to stay away from there. What if he's trying to come out? That's why we need to get you your lawyer so you can let your lawyer know, hey, this guy's not leaving me alone. It's not meant to be a trap. You know, if he is coming around you, that's not you coming around him. But if he shows us his phone and there are all these texts from you, that's a problem. Are you guys coworkers or friends or enemies or? My dad, I didn't know him there. Okay, but he's somehow still trying to be around you. Okay. I want to know him. All right now. All right. And then there's some Lanier Street apartment you're supposed to stay away from. Okay, good. All right, you're good to go. you will get notice when you need to be back here, and we'll try to pass your information on to the lawyer, okay? You bet. Ms. Clark, are you ready for the bond hearing?
I am your.
Mr. Body, can we bring, get into it? Yep, Mr. Oliver. All right. Sarge, if you'd do that, that'd be great, please. How did you get on this case, Ms. Clark?
They asked for help on first appearance, so I keep the, murder cases.
Oh, so you'll hold it till it's indicted, or do you keep it all the way through? Okay. No, he can take a seat right there. Thanks.
Somebody.
All right, let's see if Ms. Rivers is ready to go. Good morning, Ms. Rivers.
Good morning. Yes, I'm ready.
Excellent. Well, let's go on the record. This is 25 PI 001254, State versus Jeremiah Oliver. Mr. Oliver is here. Good morning, sir. With his lawyer, Ms. Clark. Mr. Bate represents the state. Mr. Oliver, you were arrested, it looks like maybe in February, and you've been charged with murder and aggravated assault. You have not been indicted yet, so we're in what we call this pre-indictment phase. Ms. Clark is representing you for purposes of bond, and she may have represented you at a preliminary hearing if there was one, and she'll stay with your case until you get indicted. I have your case until it's indicted, and then it will be randomly assigned to one of 15 judges. So it could come back to me, but that would be a coincidence. Odds are it will go to a different judge. But until you're indicted, if there are questions about bond, those come before me. And Ms. Clark has filed a motion to have bond considered in your case. So in a moment, she's going to tell me why you should get a bond and what that bond should look like. And then the prosecutor is going to give me his perspective on whether you should get a bond and what that bond should look like. That's all we're working through today is bond. All right? Okay, Ms. Clark, when you're ready.
Thank you. Your Honor, Mr. Oliver is charged with murder and I think they added felony murder at the prelim and aggravated assault and possession, criminal attempt to commit a felony is what he's charged with. I was at the preliminary hearing, Your Honor, and you can't identify who the assailant is in the case. There was a man that was shot in the dark, and I guess the camera in the parking lot captured what was going on, but there's no way of identifying who it was. And Mr. Oliver has evidence showing that he was not at that location at the time of the incident. And, Your Honor, he's 24 years old. He graduated from high school. He was going to Albany State in Albany, Georgia. Your Honor, if he's given a bond, he would work with his father, Reginald Arnold, who has a landscaping business that he was working with him before. He does have a prior history in Albany, trespasses and other things at the college and in Doherty County, Howard said. He would live with his father at 1463 Westview Drive in Atlanta. He is a lifetime born and raised in Atlanta. He isn't a risk to flee to jurisdiction or to commit any felonies while on bond. He would be able to be on ankle monitor if the court would allow, and also a curfew other than for work and for school or medical purposes in court. And we ask that you give him a reasonable bond. As I indicated, I did check his GCIC and he does have, but he doesn't have any FTAs or failure to appears in these cases. I think he said that he's supposed to go up for an arraignment in April of this year. These happened in 2020 and 2022.
Arraignment down in Dougherty County.
Yes.
Okay. Mr. Oliver, where'd you go to high school?
Mays High School, Berkeley High School.
Mays and Berkmar? You graduated from Berkmar or Mays?
Graduated from
Okay. And how far did you go at Albany State?
I was sophomore year, second semester, sophomore year.
Okay. All right. Before I turn to you, Mr. Bate, Ms. Jackson, good morning.
Good morning, Judge.
Do you have any criminal history information on Mr. Oliver?
Yes, there are 7 cycles. The last arrest was May the 4th, 2022 out of Daugherty County for 2 counts of aggravated assault and possession of a firearm during commission of a felony. There was no disposition for that arrest. He does appear to have an outstanding hold out of Albany, Georgia, for a failure to appear. The date on that warrant was June the 13th, 2024. He does have a misdemeanor conviction and a sentence. Someone in 2022 out of Daugherty County for criminal trespassing and giving false information to an officer. And he received a nolo contendere sentence in 2021 out of Daugherty County for criminal trespassing. Nothing in addition, Your Honor.
All right. Thank you, ma'am. Mr. Body.
Thank you, Your Honor. The state would respectfully request he deny defense counsel's motion for bond for several reasons. The first, the state would submit to the court that the defendant is a significant risk of flight. As you just heard from Ms. Jackson, Mr. Oliver does have a recent failure to appear at Albany, I think with June 13th of 2024, where he didn't appear for court. In addition, Your Honor, the state would contend that Mr. Oliver is a significant risk of committing felonies pending trial. Though he doesn't have any felony convictions, he's out on bond for 3 separate felony cases out of Dougherty County. Those would be all from 2022 and 2023 cases. The first being a theft by receiving stolen property, possession of drug-related objects, and possession with the intent to distribute marijuana. Also, a possession of a firearm with commission felony charge. Roughly thereafter, on May 3rd, 2022, he was arrested and later indicted on an aggravated assault case, also out of Dougherty County. He's charged with 5 separate counts of aggravated assault and a possession of a firearm during the commission of those felonies. And then lastly, Your Honor, we have an additional case out of Dougherty County. Well, no, I apologize. They must have just added the possession of a firearm charge in addition to that case at a separate time.
Got it. So 2 cases, theft by receiving plus drugs and a gun, and then 5 ag assaults, all 1 case plus a gun.
Yes, Your Honor. In both those cases, he was out on bond at the time that he committed these offenses. And the failure to appear in Dougherty County to both of the cases that I just mentioned to the court. I'd also submit to the court that the defendant is a significant risk to the community and the people in it based on the facts and circumstances of this case. I know Ms. Clark indicated that there's a video, and you can see on the video a male shoot another male as he gets out of the car with his hands up. And then after he's shot the first time in the leg, he then begins to attempt to crawl away. And the state's contention that this defendant then, as the victim was crawling away, was then shot in the head and was killed. This defendant is identified by who I would say are his co-defendants. Later, his girlfriend's cousin, who was in the house and present during the time in which this defendant and his girlfriend were speaking, overheard the conversations about the murder and what the defendant did and why he had to.
These would be meaning post-offense conversations.
Yes, Your Honor, and why he had to put his girlfriend in that position to now lie for him and see that he committed this murder in front of her. Further, his cousin, I believe his name is Mr. White, also spoke to the police upon his arrest, and he indicated to the Detective Deegan, that this was a planned armed robbery of Mr. Willis, and it ended in Mr. Willis's life being lost. So based upon all of those circumstances, Your Honor, the state would respectfully request that deny defense counsel's motion for bond.
Okay, thank you. Ms. Clark, as always, as the movant, you can have the last word. Anything you want to add to what you've already shared with me?
Yes, Your Honor. Mr. Abate doesn't seem to understand that my client is accused of the crimes. He said that he committed new offenses while out on bond, but at this point, there isn't a conviction. He has no convictions, and he's only accused in this particular case. I disagree with the facts that he stated as far as what I saw at the preliminary hearing and heard at the preliminary hearing. The other two young ladies haven't had their preliminary hearings yet, so I don't know exactly what will be said there. But at my client's preliminary hearing, it's alleged that the co-defendant, Ms. Smith, said that my client said something after the fact that he committed this crime. But we're challenging what the statements are of the co-defendants, obviously. And I believe that he indicates that he missed the court date in June, but he contacted them and made arrangements for it to be rescheduled, and apparently is rescheduled for April of this year. So he wasn't trying to flee the jurisdiction or avoid prosecution, Your Honor. He actually said that they have his correct address and that he's been in contact with them.
Judge, I neglected just to represent to the court. The victim's family members are here. Mr. Willis's uncle, Mr. Ferris, would like to make a very brief statement to the court when the court thinks that appropriate.
Sure. No, I will certainly hear from them. And then Ms. Clark, I'll turn back to you again in case there's anything you want to add. Let me just ask Mr. Oliver a quick question. Ms. Clark shared with me, Mr. Oliver, that you've been in touch with the authorities down in Dougherty County trying to reschedule your court date. Was that before you got arrested in this case, or since you've been in custody here, you or family members have been trying to get things reset down in Dougherty? Before? Okay. All right. Thank you. Mr. Abate, when you're ready.
Right here, let's just speak into that microphone. State and spell your name for the record.
Okay. My name is Anthony Ferris, Anthony, Ferris, Farris.
Good morning, Mr. Ferris.
Good morning.
Thank you for being here. And Mr. Abate wasn't skipping you. He just was focused on getting his part out. So it's important that you share with me your thoughts about bond and obviously the loss your family has gone through. We're not talking today about punishment or guilt or innocence. It's really just this narrow but important question of should Mr. Oliver be given a bond, and what should that bond look like?
Yeah, and I won't speak on should or shouldn't. What I always look at is, you had individuals in a situation, and I always look at energy. When things are done, you can't get that back. The impact that has impacted our family is my 84-year-old grandfather, my father, which was his grandfather, who helped raise him, and his 81-year-old grandmother. And then you think about the kids, he has 4 kids, 38 years old. And
Mr. Willis was 38 years old at the
38
time.
years old.
Okay.
An interesting part, we had a funeral home that we actually helped a friend of mine build, and we actually had to carry that service out at that funeral home, which was owned by another company. But the financial impact has put a burden on his grandfather, his grandmother, and myself, because his mother is on disability. And so one of the kids are actually staying with his mother, which is Miss Willis. So I always want to look at it like this. If the accuser has a job and can commit to society and is doing what he needs to do to help, if he may have kids or they may have kids or whatever, support those kids. But now we're having to support my nephew's kids. And that's a burden on us, a huge financial burden. Because you've got the young baby, which is the girl, the last one. She cried for her dad because he got her every weekend, and just trying to do the right thing. What's right, what's wrong, that's nice. I'm gonna leave that up to the courts. But what I will say, if, they just need to find out the way so we never have to be in this situation again, and no other family would have to go through this. The crime out here is just, it's just senseless to me. And energy, I just want people to understand, when energy is released, you cannot get that back. It's already taken. So that's my statement.
All right. Thank you, sir. I appreciate it. Thank you for being here.
Thank you.
Thank you, Judge. I apologize for the mistake.
Okay. All right. Ms. Clark, anything else you want to add?
So, Your Honor.
All right. So Mr. Oliver, I am not going to set a bond right now. What I'm going to do is reach out to folks down in Dougherty County to sort out, is there in fact a warrant for you there? And is there a way for us to get you down there to take care of that business? Because if you've got a hold there, getting you a bond here is just going to get you shipped down to Dougherty. But if that's where you need to make a court appearance, then we ought to figure out how to get you down there and see what their next steps are. That would return you here. And if you haven't been indicted by then we can talk about bond again. But I want to sort out what's going on with the Dougherty County cases, not meaning what the facts are, they're not my cases, but procedurally what's going on, so that you're not missing us and missing the 2 cases down there. So for now, I'm going to leave you in a no bond status. We'll work with Dougherty County. And if that gets cleared up, I don't mean you resolve the cases, but this hold that's down there gets cleared up, then we can revisit the question. By then you may be indicted, in which case you and I don't have to talk about bond anymore. The judge to whom your case is assigned would engage with you. And if Ms. Clark is sticking with it, it'll be Ms. Clark, but she typically hands the case off to the trial attorney in whatever courtroom that is. Okay. All right. Ms. Clark, thank you for your time. Thank you, Mr. Abate. All right. Did we have any arrivals? Oh, I mean, Ms. Wood got here, but no new defendants. So let me call the name again. Jamal Nollie. Going once, going twice. Nope. All right. That'll be a bench warrant. Miguel Cargill. Oh, all right. Isabel Hicks. Oh. Robert Brown. That's it. Ms. Nelson, do you have an update on the Gwinnett situation? I want to let our interpreter head on his way if we don't think we're getting that connection from Gwinnett today.
What we got set up.
Barney's Taylor.
Ms. Rios, do you have any cases you want to talk about?
We can update the people go.
Great. Who would the first be?
Ronald Lawson, I will get that waiver filed, and I have good contact information for him.
All right, Mr. Lawson, let me look at your case. Sure, I've got good contact info for you. We're not gonna get this gentleman from Gwinnett today. I'm shifting gears. Hold on one second, Mr. Lawson. So, Mr. Interpreter, thank you for being here. Do I need to sign anything for you or are you good? I would gladly do that. You give it to Deputy Gordon?
And next to the blue X.
Okay,
At the bottom.
thank you. Something about a work release program he's in. All right, Blue X. Mr. Bernal?
Yes,
Thank you.
thank you, Judge. Good afternoon.
You too. All right, Mr. Lawson. The Holly Street address is a good address. Who lives there? Your mother and you? Okay. And your bond is going to be ancient given this case, but let's just take a look. See if I can find it. There it is. You're supposed to stay away from a QT on 10th Street. You're still staying away from there?
I don't live it anymore. It's in Wall
Whoa, okay, but wait, how is Holly Street a good address for you then?
You should alert me if I get court.
Okay, so that's a safe place to send mail. All right, and you've got good contact information for Mr. Lawson.
Yes, sir.
All right, so we'll do a scheduling order. Ms. Rios will keep you posted. You'll come back here next either because she's filed some motion on your behalf or maybe you and the state have worked something out, okay? Just keep in touch with Ms. Rios. All right, thank you.
Yeah, so he said police Taylor, but he must have been.
So you did your, oh, no, this waiver was in non-complex. All right, so you'll do a waiver?
Yes.
Okay.
In regards to Mr. Hernandez, he was involved on his Gwinnett operations or
Oh, that's why he is in sort of in custody doing work release?
yes, and also into the Gwinnett County jail law. He's said release next week.
Okay. Well, we need to figure out how to get his case rolling here. And Ms. Cabrera is on that one, but we're resetting it. Okay. I'm sorry, Ms. Rios, you were going to say?
I don't remember.
Okay. Reset, Mr. Hernandez. Mr. Sinkfield, has anyone spoken with Mr. Sinkfield? You,
Yes, Ms. Taylor.
or you have hired an attorney? Let's see if it's in the system.
Judge, I don't see like a waiver or an entry, but I saw in the case management notes from February and non-complex that says Attorney Beverly Taylor, but that's the only thing that indicated to me.
What are is that some secret thing on your side? Or is that in Odyssey, case
No,
management
the
notes?
Case management hearing notes, like the court date notes.
Oh yeah, there's some kind of, let's see. Mine won't scroll over more, but okay. When did you hire Ms. Taylor? Pardon me?
A couple of court appearances ago.
Okay.
I'm not sure.
That's what I don't mean like, was it March 1, but was it a few months ago, a few years ago? It's recent? Okay. And you paid her the whole amount? Okay. All right. Well, we will need to, figure out how to get in touch with her and, reset this so, she can be here as well. Before you go, I've got a Lee Street address in Decatur. Yeah, that's a good address for you? Okay, well, we know how to find Ms. Taylor. You'll get notice at that address, and when you come back, we'll try to do what we were gonna do today, but with Ms. Taylor around, okay? Any questions? All right, see you next time. Do you think Aaron Rodgers is gonna end up on the Steelers?
I want to see it, man. I'll give you up. I ain't gonna make it go back. That's all right.
Okay. How about Elton Taylor? Nope, we're waiting on that. We took care of Hernandez, bench warrant. Ulysses Greer. That's the one we let go. He needs conflict counsel, not named Cabrera, apparently. And bench warrant, Lasana Pitts.
Talk to Ms. Pitts and I will get a waiver filed.
All right, Ms. Pitts, let me get your case up on the screen here. So Ms. Rios will file a waiver on your behalf. That's just waiving arraignment, meaning she's entering a plea of not guilty on your behalf. You know what you're charged with? Okay, it's old. It's a new indictment, but old set of facts. Your bond is from almost 2 years ago. You're supposed to stay away from Aroka Pitts? Okay, that's the same last name. How is that person related to you? Your daughter, how old's your daughter? Is that a practical condition to say that you two stay apart?
Well, I'm at my oldest daughter's household.
Okay,
I'm not even in the household. I've been.
all right.
Since I got out.
She's old enough that she doesn't need her mom taking care of her.
Right. She's
Oh.
graduating next week, you know.
Where, from where?
Douglas High School.
Okay. Well, if you're interested in going to her graduation, you should talk to Ms. Rios so we can make that happen. Pardon me? Okay, so just talk with Ms. Rios and she'll need to talk with the prosecutor. And then if no one disagrees, then at a minimum, we could say you can go to the graduation, but it may be enough time has passed that we can say that you can be around Rakia, you said? As long as there are other people around, just no one-on-one. But I'm not saying that yet. I want Ms. Rios to talk with you and then, who will handle this case? Is this a Ms. Nick's case?
That's my case, Judge.
Oh, okay. How come?
So it's a family violence, but because of the parties, I believe that is a mistake.
Explain, like, why does it matter? If it's family violence, I thought that goes to someone not named your name.
So I'm still getting a grasp on it, but maybe.
Oh, family violence under the statute is still a parent and child, but family violence in our office is just intimate partner.
Oh, huh. So two brothers going at it, or a parent and a child, chargeable as family violence battery or family violence aggravated assault, but in your office, unless they had also a special relationship, which might bring another charge, then it stays with the line ADA.
Yeah, I think some like parent and child would go depending on the injury.
Okay, yeah, because cruelty.
And the age of the child.
Okay, all right, but Rokia Pitts was not a real little kid at the time. Okay, got it. So talk with Ms. Rios about loosening this up so that you could at a minimum attend graduation. And we'll see what we can do. Any other questions? No? Okay. All right, Ms. Rios, can Ms. Pitts go?
Yeah, I'm just gonna talk for 1 more second, but she would be excused from the clerk, so talk her outside.
Okay. Ms. Dilligard, any issues with discovery you're aware of in the case?
Not that I'm aware of, Judge.
Okay, all right, thanks. How about Kaylin Aiken? That was Ms. Guess maybe that person's in custody. Aiken, number 11. Okay, so we'll come back when she comes back. We dealt with Oliver, and then there's Taylor. So I think the big one left is Mr. Taylor. Do you want to chat with him?
I'm just working with you, and I'm just working on some stuff, and then we'll be ready shortly.
Will we be resolving everything, or just doing revocations? All right, is that your understanding?
Yeah, I think he wants to go, not.
Yeah, it's not.
Okay, do that.
I'm not touching it. That's why this one and the probation, and when that gets indicted, it'll hopefully land elsewhere. Got it. Yes.
I guess Robert Brown hasn't shown up.
This one, I don't know. So it's got Nickerson is the only one that's work. Did you add anything to the new anything or
This name.
okay? Yeah, I want to
The one is on steroids. As an origin, which is not just exactly how close I that is sexy.
Because he wasn't arrested. But it's all, but he's in the jail, right? He's on the, but it's coming down to the case manager side, right? Nothing, the PI number, it's not a case.
Yeah.
It's not. It does other price. Just a house.
Would it be added on our side? So just add it on our side, make a case.
I can do that.
Wow.
I don't know how to do that.
Oh, I can do it. What are the charges? Just send me an email, I'll do it.
I'm just gonna.
Oh.
She said in there, she has a lot of police on her son.
It's like we like how would you like keep him back. I mean, I don't know if he has because he's got him about his head. Like,
Well, we have,
You get upset.
yeah. So it's like a
She said she breaks. That family. And I think in this thing, there's still a, you like, but it's not like. She still needs to provide for herself, her kids, if she has, that's still her age. I think but at least for the, I mean, I'll be fine.
just a little more.
Okay, so, yeah.
Yeah, so we just make it, yeah. And we can do it. Just send it to me. I'll put it in the attorney manager. And then once I put it in the attorney manager, they'll make it in. Case goes back.
So,
Yes.
do you think Thank you. That's the
Yes.
code of behavior, because it's not been correctly with government. Can we do, he's worried about his child. Is there any way that we can get
With the pen work.
him? And do you think if I could live it all?
This is your hand up, that must.
Yeah, that's the two gun, the our robbery. Yeah.
If you look on the other people.
As long as it's not his brother, but the other person would probably, and he's saying like, blah, blah, blah. I don't think he had anything, I think it was just presence, if his brother is younger. 15, 17, 15, 17. What's the brother?
I forgot that, but what is like, whatever.
Mr. Abate,
Yes, Your Honor.
I didn't hear anything from you about scheduling conflicts on the case that Mr. Bass has. You hadn't been focused on it, and so you were going to check to see if any of that, it wasn't your scheduling conflicts, it was witnesses, because you hadn't been poking at those witnesses.
I emailed, I attempted to make contact with the lead detective, so I'll do it again today.
Okay.
To make sure that if I have any scheduling conflicts, I find out about them today.
Great. I just want to send an email out soon to say, here's what next week will look like, and we'll start with Dandridge, but then we've got two favors and I'm just blanking on what, Dennis?
Right.
Yeah, Dennis. And Dennis is ahead of, is favors the right name?
Yes.
Yes, yeah.
Yes, Your Honor.
But of course, what we have very first of all is Mr. Christmas.
Oh, yeah.
Yeah. Hope you guys are ready. Mary.
And then I know Mr. Bass is his name, right? So I know he's been doing some open record stuff. He wouldn't tell me because I said I'd be happy to assist.
Yeah.
But he wants to do it on his own apparently. So
I've never dealt with Mr. Bass.
Me either.
But when I poked at him, it sounded like it was like personnel files.
Right, and then something to do with the victim. So depending on what serves me, I'm not certain as to whether it would require me to do additional investigations or whatever, but I just
We'll see. It also depends on when he serves you, so we'll see.
Yes, Judge.
Okay.
Yes. They served him the warrants while he was in custody. That's two judges. I'm like really, it's like black, like glow in the dark. It's just the little things in life.
Are you always? Sorry, when would you want to do this? Yes, under. So. Here. Yeah. And from the right. So I can surprise it all, yeah, it's, so they are like.
All right, I'll be back. Ms. Nelson has summons me. Ms. Rios, is it your client who's back there? Why don't we do that before we do Mr. Taylor? I assume that'll be quicker. It's just saying, hey, and waiving arraignment, all that kind of stuff. Okay. Are you all able to start at 1 this afternoon instead of 1:30? The monthly meeting that I was supposed to have from 12:30 to 1:30 got canceled. And so we could start a little earlier and be done a little earlier unless you've already built into your.
At 11 or 12.
Okay, how about 1?
Okay.
Okay. If we have people here, we can look at that calendar. I am not hung up on it being in the afternoon. The earlier we could start
I'm gonna text my clients, get her to prepare early.
Okay, all right. They won't be late if they get here at 1:30.
But they don't. Okay. Okay.
And did you see my email on yeah, that he's not supposed to have it, it's just supposed to be a parole. It's a parole. Yeah. It looks like he picked up some. Well, he wouldn't be, I would only be representing him if he had the probation revocation, but since he's not, he's just, we don't have anything to do with it. It's not out. Yeah. Or read a probation. Yeah. So they just need to come get him. Right? Well, they already have. Oh. So there's actually nothing for us to do. Okay, so we could just, I'm just gonna scratch him off the calendar. Yeah. Okay.
All right, I'll see you guys later. Hey, so Christmas, is that gonna, what is that?
It's not.
Not.
My recommendation is veterans for 3,000.
Mm-hmm. Is he gonna do it? Is it a speedy trial? So if he doesn't do it, are we gonna go to trial? I'll try it with you.
I mean, yeah.
I mean, I'm ready on.
That would make the victim doesn't want you to.
That's what I'm gonna. They didn't. Well, I know the different shell system. Mr. Dan.
Please present yourself.
The floor is yours.
But yeah, it's a driver. Sure.
All right. Well, let me know.
Okay.
When I was in Alabama, there was a sexual assault child case, and somehow during the investigation, and this defendant's defense was, "I have a micro penis."
It's not bad. It's embarrassing. It's not bad. But yeah, that would be great because that would mean that both weeks wouldn't be mine.
Yeah.
But I'm feeling that both could be mine. All right. Yeah.
This guy got 19 years probation. See. Yeah, every time. This is great. Yeah. Let's get every time. Is the Tennessee case, that's part of, he has a Tennessee.
Yeah, and that's what the judge was saying, he was also including.
Got it. Cause I'm like counting, I'm at 4 previous revocations and I'm only in 2013. Do you know how many revocations we had on that case? I see one in 2018. Jesus Christ. Let's see. 2022. I see 8 revocations.
Yeah. Hey, something, I didn't agree. Yes. Sure.
How come you're here, Ms. Nix? Other than it's always wonderful to have you here.
Well, Judge, Mr. Taylor, one of his new charges is a rape, and so I'm
What?
holding on to be present for that.
This guy with all these shoplifting cases? Is it unindicted?
It is, and in fact, he was just arrested for it, or, well, he was already in custody when the warrant was served on him. So the warrant was served on him on March 23rd. It comes from, the incident wasn't last summer, but it was like codicit, he was already a suspect, but it was a codicit confirmation deal that hit on March 20th. I think.
Wow, and the victim couldn't even talk.
Yes.
That's a very different profile than I was developing, seeing entering auto and shoplifting and all that. Ms. Rios, is position 1, Ronald Lawson, was that yours?
Yes.
Okay, thank you. Just need to update our papers. And would you like Deputy Gordon to bring Mr. Akins out now?
Yeah.
Okay.
Who we all just talking about? Before this.
Oh, never mind, okay. It looks like
Okay.
But it sure is a reason to close out his open case. Okay. Hey, Mr. Akins, just right on up there. Good morning. I'm Judge McBurney, and your case has been assigned to me. Ms. Rios is your lawyer, and she shared with me, if I'm remembering correctly, that there's a potential for you to get into our accountability courts, also known as drug court. Is that right?
Yes, sir.
Is that something you're interested in?
Yes, sir.
Okay. Have you already had your intake interview? You've met with someone from the accountability courts?
Yes.
I think all they need are your medicals to make sure that it's safe for you and for the program for you to be in it. And then you and Ms. Rios would talk with the prosecutor about, are you going in there by way of plea or diversion or what? Today is your arraignment day. All that means is Ms. Rios, I believe, is waiving your arraignment, which means she's entering a plea of not guilty on your behalf. I'll put a scheduling order in place to make sure the case moves forward. Sounds like you're going to be out ahead of that because if you do get admitted into accountability court and that's something you are serious about, I suspect Ms. Rios will get you back here real soon to enter that plea to your case and get you into drug court. And it's drug court that you're thinking is the right fit for Mr. Akins?
Yes, sir.
Okay. Mr. Akins, any questions about any of that?
No, just like you said it all. I have no. I'm just trying to figure out the next date. You said.
As soon as they let me know you're accepted, I'm gonna try to get you on the calendar, so just have to.
Yeah, we're in court lots. And so once, assuming drug court says yes, then we can get you in here in person, or on Wednesdays, we do Zoom court where you go into one of those booths. And we don't need to delay things for that. Two things about drug court. One, orientation is on Tuesdays. So if you, I'm making this up, but if next Wednesday you entered a plea, you wouldn't start drug court till that following Tuesday. It's not right away. It's every Tuesday. Number two, are you going to need housing, or do you have a safe and stable place to stay?
I need housing.
Okay. I will pass that along to drug court, along with your name, so they know as they're considering you. Drug court is able to provide supportive housing for the first 90 days. And it can be extended, but once you're kind of up and ideally working, then you're able to contribute some. But at least for the first 3 months, we're able to find you housing. Probably not a place you'd want to live forever, but it's a roof and it's your space, and it is a place to start. Okay?
Yes, sir.
Tell me what drug or drugs you feel like you struggle with.
It was alcohol and marijuana with meth.
Like you mix the two?
Yes, sir.
All right. Got it. Well, drug court hopefully would be something that helps you. We'll see what they say. It sounds like right now it's just a question of the medicals, and we'll go from there. Ms. Rios, anything else on behalf of Mr. Akins?
Sure.
Ms. Dilligard?
Nothing further, Judge.
All right, Mr. Akins, we'll see you soon. Ms. Wood, are you ready for Mr. Taylor, or do you need to chat with him more?
I am ready, Judge. I was gonna request if we could handle these probation matters before the plea. I think that'll make sure that everything goes through.
Okay. Does he know we're doing both things?
Yes.
Okay. So Ms. Rios, you'll do a waiver for Mr. Akins if you haven't already. Okay, so we'll get it moving down that path. It just seems that sooner than a motions hearing date, we'll know he's into drug court.
Yeah, I emailed them 2 days ago and they're just like, they probably will have it by the end of the week.
Okay.
Because his bond is so low, there's no point in a bond hearing.
Okay. Hey, Mr. Taylor, come on up to the podium, please. Good morning.
Good morning.
Ms. Rivers, are you ready to take down Mr. Taylor's cases?
Yes, I am.
Great, let's do that. Mr. Taylor, you are here on 4 different cases. 3 of them are old cases, meaning you already pled guilty and you're on probation, and they all came here. They weren't cases you had with me. You had a case with Judge Cox. You had a case with Judge Barwick. And I think you had a case in what we call our non-complex unit. But on all 3 of those cases, you were on probation when in October of 2023. So I need you to go back a year and a half. This was a while ago. You caught a shoplifting charge here in Fulton. And that charge has now been indicted. That case has been given to me. So I've got your shoplifting case. It's a new indictment, old shoplifting. But that shoplifting is the basis for the 3 revocation warrants. So what we're going to talk about today is the shoplifting, but what we're going to do first is handle these revocations. And then if you're ready to, it sounds like we could also move forward and resolve the shoplifting case. So all 4 of those things are behind you. But at a minimum, you're on the calendar for a revocation hearing. Basis for the revocation being, I'm gonna call it new because it's a new indictment, the new shoplifting. Does that make sense? I laid a lot on you, but does that make sense? I need you to answer out loud.
Yes, sir.
Okay, because the court reporter, who you can't see, is taking down everything that's being said. So your 3 older cases are 10 SC 95364 and 19 SC 169089 and 22 SC 182836. You've got about a little less than 4.5 years remaining on your probation in the 10 SC case. In the 19 SC case, you've got about 6 years and 2 months. And then in the most recent case, the 22 SC, you've got 7 years and 7 months. They're all running at the same time. They're just different length sentences, and we're going to deal with all of them. It's alleged in each of the 3 warrants the same things, that in October of 2023, you committed a theft by shoplifting here in Fulton County. And then also in February of that same year, 2023, the probation officer tried to see you at your last known address, which was on Ellis Street. And someone who was there said, that's not where Mr. Taylor is anymore. And the phone numbers that you had given to probation were out of service. So the more serious violation is the new charge. What we call them technical violations, where you were hard to find. Whether your phone was out of service or not, you weren't particularly easy to find. I'll tell you, I'm much more focused on the new charge than what we call the technicals. And I think that's going to be really what drives things here. Ms. Wood, is Mr. Taylor admitting to being arrested for the theft by shoplifting and not being at the address where probation thought they could find him?
Yes, we're admitting, Judge.
Okay. Do you have a recommendation as to what the consequences for those violations ought to be?
Yes, Judge, we're asking the court to consider revoking 1 year. He's done approximately 145 days total. And I would point out, he also has to go visit DeKalb County for a hold before he goes anywhere, Judge.
Okay. Do you know what the hold is for, Mr. Taylor? What DeKalb wants to talk to you about?
No, sir, but only thing I know is they say it was a whole base at Sunshine. I don't know where it was, but.
Okay. Well, let me ask Ms. Simpson. She's with probation. Did Mr. Taylor have probation out of DeKalb?
Judge, it appears that he did, but right now we don't show anything outside of our cases.
Our 3 cases. Okay. So that might be, Mr. Taylor, something that gets cleared up pretty quickly once you get to DeKalb. But as long as that hold is there, only DeKalb can lift the hold, and they'd lift it once you made it to DeKalb. I'm here, and they can figure out what the situation is. It could be probation. It could be charges you're not remembering. I don't know. I'm not pinning anything on you. I don't know what that is. other than to tell you, you'll find out when you get there. And you'll be earning time on whatever we do here, that whole time you're going over there, et cetera. All right, so your recommendation is to revoke a year. Ms. Dilligard, what is your recommendation when we are dealing with the revocation side of things for Mr. Taylor?
I'm just trying to understand whether or not we are taking into account the new rate charges.
That's not on any warrant I have in front of me, meaning probation warrant. I have seen the warrant as in Detective Armand swore out a warrant, but that's a East Point police officer. I haven't seen anything from Department of Community Supervision about that.
The petition was updated, but the warrant was not, because it was all, the wasn't systematically. We wouldn't be able to process another one. It would look like we got 6 warrant versus 3.
Okay, but the petition has been updated and the petition's been signed? Okay.
You signed it, last Thursday.
Okay. I don't know that Mr. Taylor has notice of that. And so my thought is that what the record will be very clear about is that this revocation today, assuming we go forward with it, contemplates the shoplifting and the being difficult to find, and that's it. And so Ms. Wood's recommendation of 1 year, I'm hearing, is in connection with shoplifting and not new allegations that I don't think have been indicted yet. Is that correct?
That's
Okay, all right. So thank you for asking that, and I'll make sure the record is clear when I impose the revocation, what the basis is. So Ms. Dilligard, assuming that what we're dealing with this morning is shoplifting charge and absconding, what is the state's recommendation?
recommendation is to revoke the full balance, Judge, on all of the cases.
So 7 years, 7 months for the shoplifting and the absconding.
Yes, Judge, also I want to indicate that there have been 8 previous revocations on that 10 SC case. And so this would be his 11th shoplifting conviction.
So some of the previous revocations, I'm pulling up the 10 SC case now, but some of the previous revocations were for other shopliftings?
That's my understanding, Judge.
Okay, let's see what the docket says. So there was a revocation in July of 20. I'm not going to march through all of them, just a couple of them I'll pull up. That was a failure to report. And Judge Barwick continued Mr. Taylor on probation. In 2022, there was a revocation that simply continued Mr. Taylor on probation that was based on his plea to the 19 SC case, which is the theft by receiving stolen property. That's one of the cases that we're here on. Let me see if there are any others. Gosh, there are a lot, so I'm not going to look at all of them. But I see your point. Ms. Simpson, what, as you look back on Mr. Taylor's performance on probation, do you have a perspective as to what ought to happen?
To narrow it down, Judge, in a short summary, it looks as though there are a lot of theft issues and some drug issues.
Okay. I am seeing lots of revocations, and a lot of them, it was back in the Judge Lovett era. So it was just continue on probation, continue on probation. Mr. Taylor, what's the longest you remember ever being revoked? if you can remember. You don't remember? Nope, okay. All right. So does DCS have a perspective as to what ought to happen?
In light of the unindicted, the circumstances of the unindicted case, my recommendation is to agree with the state's advice.
So, but we're in a funky situation right now in that I'm not, I know it's like a thought experiment, but it's.
But my concern is not the charges, it's the victim.
Okay, but that information isn't in front of me right now. And so I am weighing another shoplifting. Sounds like there've been many. It was from 23. 10 prior revocations, that's a lot. So doesn't seem like probation is having its desired effect. Although, I don't know what the sentence was in this 10 SC case. It must have been 1 million years of probation. That's often not a.
I saw 19 years. I was looking for the sentencing drill and I can't locate it either.
It's right here. It's old enough. It's one of these handwritten, but it was 20 years. Yeah, so 19 and a half years on probation by Judge Lovett. Okay.
So Judge, my recommendation is then probation is going to revoke the balance of the Tennessee case to close it out. As well as when there's other cases. And just the moving state.
Oh, I see. Okay. Because that one is the four. Okay. Got it. All right. Ms. Wood, anything you want to add on Mr. Taylor's behalf?
Just Judge, he tells me that address, was one that was his sister's. I've reminded him it's, his duty and his responsibility to be in touch with probation. He tells me that his mother, was having a lot of health issues, and that's one of the reasons he was helping take care of her, and, sort of reporting to probation was not forefront of his mind at the time.
Sure.
And then, of course, we're going to be handling the theft by shoplifting after this. So I'll tell you more about that.
Okay. Let me pull that up. You said that Mr. Taylor was taking care of his sister or his mother?
My mother.
How is your mother?
My mom, she had a stroke and she paralyzed on one side of her body.
So who's been taking care of her since you've been in custody?
My sister, my brother, and my nephew, and niece, they've been back and forth over there, but that's why they need me back out there to help them.
Are the people you mentioned, your sister and your brother, et cetera, are they local? They're in Atlanta?
Yes, sir, they're in Atlanta, but I got their numbers in my phone, but I don't know about her or nothing. And right now, they don't even know they probably don't even know where I'm at right now. That's why.
Okay. No, I understand that part, but they're not having to travel from Texas to take care of your mother.
My sister, she travels. My sister, she a truck operator. My sister work at the hospital and she a truck driver.
Okay.
And plus, my other sister, she a nurse and everything, but she go around to do patients and all that. That's why my brother, he disabled. He can't hardly do nothing, but he trying to help my mom and all that.
Okay. And is your mother in her own home? Is she in an assisted living home?
She in her own home.
Her own home. Okay. And who stays with her?
Me, my brother, and my nephew.
How old is your nephew?
My nephew, he just turned 21.
Okay.
That's my brother's son.
Got it. And the brother who stays there? So your brother and his son stay with your mom? Okay, I'm glad she's got them. All right, Mr. Taylor, anything else you want to add?
I got a lot. Yeah, I got a lot, but
Not for now.
I just want to get this over with by going to the care and get that taken care of and try to get back out there to my loved ones, get back out there to my son. Plus, I got a son I need to, I've been taking care of.
How old is your son?
He just turned 2.
2? Where's he staying? With whom?
Right now, he's staying with his mom right now.
Okay. All right. Well, congrats on having a little boy. So, Mr. Taylor, I do find that you violated the terms and conditions of your probation, and that it happened again. There is a pretty long history of probation not going well for you. I don't know what underlies it, if there is a substance abuse thing you struggle with, or mental health, or life is complicated. Life is complicated, I know that. But just looking back through these 3 cases, in particular, the oldest of the cases, it was almost like every other year, something wasn't going well. And your obligation when you're on probation is to do your best to stay out of trouble. And that's not what happened here. I appreciate that the shoplifting was a while ago, but it nonetheless is inconsistent with the requirements of probation. I promise I'll hear from you in a second. You also have a new situation that kind of overshadows everything. That's not what we're dealing with as we handle this probation. But as you're thinking, hey, I need to get out and be with family and everything like that, I don't know that that new situation is going to be the kind of situation that you are going to be out in circulation until it's resolved. Not my case, and another judge will be working through that. But I just want to manage your expectations that I might not go along with the state's recommendation here, but even if you were to finish your time, you get credit for good time, you get paroled out, whatever it is, this new set of charges here in Fulton are the kind of charges where if you did get a bond, that bond's going to be a big old bond, and it may not be one that you and your family can make. So just, I want to make sure as you're thinking about, got to get there for mom, got to get there for my son, you're mindful of that situation. But you had raised your hand as if you wanted to add something.
Well, I was finna get ready to say, my family, they've been trying to work out some things with me about grading and everything, and like gave me some kind of help. Cause my sister, she been trying to get me to get some help on grading anyway.
Okay.
Like it's like a disability, something like.
Sure. And it may well be that you qualify for disability, and it may be that you'd benefit from talking with the doctor about getting some kind of support. And I hope that's still a conversation you can have with the doctor. We got to tackle this first, and then your lawyers can see what they can line up. Okay? Anything else? Okay. Well, Mr. Taylor, as I mentioned earlier, I want the record to be very clear that this revocation involves only the new, and that's sort of in quotation marks, shoplifting, this 25 SC 000031. That's the Walmart case from October 2023, but that's what the basis of these 3 warrants is. Along with probation not being able to track you down back in 2023. I've told you before, I'm not as concerned about you being hard to find, although there were some examples of that looking back on how you did and didn't do with probation earlier this decade. The big one is the new charge, meaning the shoplifting. Given your history on probation and given your criminal history in general, I do think that a larger or longer revocation than what Ms. Wood recommended is appropriate. And so I can find all those numbers again. What I'm going to do in 10 SC 95394 is revoke 3 years and 5 months, and I will terminate the balance. So that'll be closed out when you're done. In 19 SC 169089, I'll revoke the same amount and reinstate the balance. And in 22 SC 182836, I'll revoke the same amount and reinstate the balance. You'll get credit for the time that you've already served. And if you want to, and this is up to you, Mr. Taylor, and you may want to talk with Ms. Wood about it, I'm prepared to take a plea in the shoplifting case and have your sentence be exactly the same. So these sentences all run together, and they close out the custodial time all at the same time, so that all that you need to worry about when you're done here today would be what's happening in DeKalb. And it could be it's nothing, but we'll get you over there. And then what's going to happen with the unindicted charges that you've got, which won't involve any of us in this room unless coincidentally, once it's indicted, it gets assigned to me. But that would be a pure coincidence. There are 14 other judges it could go to. Yes, sir. You want to talk to Ms. Wood? Why don't you do that? But I want to be clear before you two step out. Really all that's left for you to tell me about is, hey, do you want to wrap up do you want to take a plea in the shoplifting case knowing it'll be the very same thing? We're done with the probation part. It's just what are we going to do with the shoplifting? Okay? All right. Thank you. Ms. Nix?
Will we come back on the issue of the new rape charge?
So we could, that's not here. Assuming he pleads to the shoplifting case, then if that petition, he gets served with that petition, that actually would go back to, well, it wouldn't go back to whoever had the 10 SC, that's non-complex, but Barwick and Cox would get it because it's unindicted. This is all here in front of me because the shoplifting case got accused on January 7th. And then these judges said, great, we're going to shove the revocation to McBurney because, and that's right, that's how our policy works. But if Mr. Taylor pleads to the shoplifting, that's closed out. He's not getting probation on that. He would get 3.5 years to serve. Then whether there's a new warrant or petition is sufficient if he's in custody. I mean, you guys will work out the logistics. That would go before Barwick and Cox if there's going to be a revocation angle to it. All right.
Then my only other case, I believe Mr. Brown failed to appear, so I will get a.
That was the sex offender registry guy. Yeah, but he was arrested super recently. So, I think Ms. Wood said he's got a warrant elsewhere also. So he may be.
I saw that, but I believe it's been recalled.
Okay.
So.
Either way, he didn't show up. So there will be a new warrant for him. It will be called a bench warrant.
I will get that warrant to you.
All right. Thank you. Do you have anything this afternoon?
I don't believe so.
Okay.
I think it's in my calendar, so.
There's some molestations. That's not you. Cruelty to children. Man, Ms. Clark's got a bunch of stuff. And Mr. Drabick.
That is.
Our one hate crime case. Deputy Gordon, can you give this back to Ms. Simpson, please? Thanks.
Ms. Dillard, can we tell you that one's moved?
Oh, no, what happened?
Number 8, that was the gentleman that had a conflict. Mr. Tevis.
Tevis, yeah.
So it's moved to 410. at work.
Oh, that's right. That's right. Right, and Drebeck is gonna, well, it's final plea. I don't know what they're gonna do. Whether he's appearing in person. He's in Pennsylvania. I can't imagine he wants to go to trial on that, but I don't know. I don't know how they connected him to what happened. No one's explained that.
That's Rutland's case. Okay.
Yeah. What is the unit called in your office that deals with hate crimes?
I think it's called the hate crimes unit.
Oh, no, all right. That's profound.
I think 88 Rutland is
Yeah. Are there enough cases to keep her busy, or does she have a larger portfolio than just that?
I think she only handles this case because she's on a grant, so she can only handle hate crimes.
Oh.
So.
All right, let's go back on the record. Mr. Taylor has returned after conferring with Ms. Wood. Mr. Taylor, do you want to go forward with a plea to resolve the shoplifting case?
Listen,
Okay, we can do that. Ms. Dilligard will put you under oath in just a moment. You, Mr. Brakefield, will need to make sure that you answer all her questions and mine aloud so that Ms. Rivers, the court reporter, can hear what you have to say. She's appearing virtually, so she can see you and hear you, but you're going to make sure that you speak up when questions are asked. Once you're under oath, you'll need to answer the questions completely and truthfully. If at any point you want to speak with Ms. Wood in private or you got a question for me, just stop us like you did. You did a good job of that during the revocation. And I will stop and we'll figure out how to answer your question. Will you do that?
Will you ask me questions if you have questions about something? Okay, say yes.
yes, sir.
Okay, great. Ms. Dilligard, when you're ready.
Okay, Mr. Taylor, can you please raise your right hand to the best of your ability? Do you swear or affirm that any statements or testimony that you should give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You can lower your hand. Please state your true and correct legal name for the record.
Elton Taylor.
Mr. Taylor, are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No, ma'am.
Is there any medication that you normally take that you have not taken today?
No, ma'am. No, ma'am.
How old are you and how far have you gone in school?
I went to 12 from 47.
Did you finish high school or you didn't quite make it through 12th grade?
I finished
You finished high school. Where'd you go to high school?
Booker T. Washington.
Do you understand that you've been charged with the following offenses? 1 count of theft by shoplifting.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to that charge?
Yes, ma'am.
You understand that if you plead not guilty or remain silent and refuse to enter a plea, then the state is required to prove the charges against you at a jury trial.
Yes, ma'am.
Have you had enough time to speak with your lawyer about the charge in this indictment, including the facts and circumstances relating to these charges?
Yes, ma'am.
Would you like more time to discuss the case with your lawyer?
Questions for me?
No, ma'am.
Are you satisfied with your lawyer's services?
Yes, ma'am.
Counsel, do you waive formal reading of the indictment and waive any and all defects for purposes of the plea?
So waived.
Mr. Taylor, do you remember having been arrested for this charge?
So what, ma'am?
Do you remember being arrested on this charge?
Way back in, I've been staying out of trouble since 22, but
Do you remember getting arrested
no,
for
ma'am.
this case?
I don't remember.
Okay, that's all right if you don't remember. It was a while ago.
So for this incident, were you taken into custody at the Walmart?
I probably was, but I can't. It's been so long. I don't know.
I'm not aware of any pending arrest warrants for him in connection with the offense, so I think we're okay.
Okay, great. Has your attorney advised you of the minimum and maximum sentence for the charge which you're pleading guilty to today for the theft by shoplifting? It's 1 to 10 years, and since this is your subsequent, I think fourth or subsequent, the first year has to be in confinement.
Yes, ma'am.
Do you understand that today you're entering a negotiated plea of guilty, which means that the state will recommend the following sentence? Judge, my only caveat to the 3 years and 5 months, I think Attorney Wood and I agreed to do 4 years to serve 3 years and 5 months so that we can make a condition that he receive mental health treatment evaluation and a mental health evaluation, any treatment that is prescribed.
So you guys can recommend that. I'm going to just modify his probation on the probation that will still be going from the 22 SC case and add as a condition that upon his release from the revocation that he submit to a mental health evaluation and follow any recommended treatment. I'll make sure, I'll repeat that when we're done with the sentencing here.
Perfect, okay. Do you understand that that's the recommendation, Mr. Taylor?
So you understand that?
Yes, ma'am.
And do you understand that the court is not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand that the court has the right to sentence you to the maximum possible sentence on this charge?
Yes, ma'am.
Mr. Taylor, unlike the revocation where you were stuck with whatever it is I do, this case is brand new. And so if I sentence you to more than what Ms. Wood asks for, you can withdraw your plea. So I suspect she's going to ask for what I just heard. If I were to say, you know what, I've had enough with Mr. Taylor, I'm sentencing him to 10 years to serve. You could say, oops, no, thank you. That's not what my lawyer asked for. So you can withdraw your plea if my sentence is more severe than what Ms. Wood asks for. You understand that?
Yes, sir.
Okay.
Mr. Taylor, do you understand that if you're placed on probation of any kind, not related to this? Are you a United States citizen?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, you may not receive, possess, or transport a firearm?
Yes, ma'am.
Do you understand that doing so will result in new criminal charges for which you will face an additional sentence?
Yes, ma'am.
Do you understand that by entering a plea of guilty today, you're waiving any and all defenses, including any mental health defenses?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, the right to appeal if convicted of these charges at a trial?
Yes, ma'am.
Is it your decision to waive these rights, which means not to use them, and enter a guilty plea today?
She's just making sure that you do want to move.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to enter a guilty plea because you're in fact guilty?
Yes, ma'am.
Mr. Taylor, how do you plead to the charge of theft by shoplifting in indictment number 25 SC 0000031?
I'm guilty of it.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Repeat again.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes, ma'am.
And do you understand that for a felony charge, you only have 4 years from today to file that petition?
Yes, ma'am.
Judge, if this case were to proceed to trial, the state contends that the evidence would show that on October 5th of 2023, officers responded to a Walmart located at 844 Cleveland Avenue in East Point, Georgia, where they met with Asset Protection, who had this defendant detained. Asset Protection watched Mr. Taylor via surveillance camera switch his personal shoes for a pair of Walmart athletic shoes, and then pass all points of sale wearing the shoes, which he did not pay for. A pair of Bluetooth headset was also recovered from his person that he did not pay for. The total was $88.98. He had some prior incidents in the Walmart system, so a criminal trespass was also cited. Judge, I also want to bring to the court's attention, as I mentioned earlier, that this would be the defendant's 11th shoplifting conviction.
All right. Thank you. Ms. Wood.
Thank you, Judge. Mr. Taylor wanted me to share with the court that this is, he had been doing well since 2023. And so when he got arrested on the failure to appear, that was his first time being back in custody in over a year. He was, wanted to make sure that you knew that. And he also had some certificates for anger management in various classes that he had given to his non-complex attorney. She's out of the office, so he was very upset that I didn't get those, but I told him I would let you know. Otherwise, he's eager to just get this behind him, Judge. And I would note the other charge that we've been talking about, he's not been officially booked in yet. So I assume, or I think that he'll go either to DeKalb or Department of Corrections, and then he'll take care of that at another time.
Okay, good to know.
They're showing on the booking screen, but he hasn't been fingerprinted yet. He's housed at Oconee, so I don't know. It may be that he gets booked in while he's visiting us.
Interesting. Okay. Yeah, it's hard to tell. I don't know how to read these screens. There is a booking number from December 2nd, and it lists Foreign County, which is probably the DeKalb hold, failure to appear. I don't know for which. And then the probation violation, those three are on there. And then this new situation, but either way, it'll sort itself out. Mr. Taylor, tell me, the certificates that you earned, did you earn those while you were in custody, or that's something that you were working on outside of jail? When did you get things like anger management?
I did all that when I was in Oconee.
Okay. Do you know how many other Fulton inmates are there at Oconee? Are you it, or do you have a few others?
What do you mean?
Are there other Fulton County
Inmates over there?
Yes.
It's a whole bunch of us over there.
Okay. Do you stay with them? Are you all housed together, or are you mixed up with Oconee inmates also?
We mixed up with them.
Okay. All right. Anything else you want to add?
If I know of right
Okay.
now.
Well, Mr. Taylor, I don't mean to interrupt you. I'm sorry.
I would tell my lawyer, I'd like to have a copy of my papers.
I'll get it for you.
We'll definitely get those. Those have to be filed. I have to sign a few things, and then they'll get put in the system, and Ms. Wood can get you those. I find there's a factual basis for your plea, Mr. Taylor, and that your plea is what we call knowing and voluntary. Voluntary means no one's forcing you to enter the plea. You're doing it because you've talked with Ms. Wood and you've decided this is how you want to move forward. And knowing means you've understood the things we talked about. And if you didn't, you asked a question, which you've been very good at doing. Do you agree with me that your plea is knowing and voluntary?
Yes, sir.
Okay. No restitution, it sounds like, Ms. Dilligard, given the way the arrest worked out. All right. Ms. Wood, can someone in my office sign the indictment on your behalf?
Yes, Judge.
Ms. Dilligard?
Yes, Judge.
And Mr. Taylor, is it okay if we electronically sign your name on the indictment? We don't pass papers around anymore. And so if you say yes, we can sign your name that says guilty to the shoplifting to close that out. Is that okay with you?
Yes, sir.
Okay, we'll do that. Mr. Taylor, given your plea, I'm going to sentence you to the one count in your accusation, 25 SC 000031, to a term of 3 years and 5 months in custody. You'll get credit for all the time you've already served, which is not just the 128 days you've been in, but you were in for another couple weeks plus when you were arrested on these charges. You didn't get out until the end of October 2023, so you'll get credit for all that. This sentence will run concurrently with the revocations we just dealt with. And I do want to add on the record that in the revocation for 22 SC 182836, I'm adding a new condition to your probation so that when you get out, you will submit to a mental health evaluation. That's like going to Grady, like your sister was suggesting. And if that doctor recommends any treatment, that treatment will become part of your probation. Okay? Ms. Wood, anything else on behalf of Mr. Taylor?
No, Judge, thank you.
Ms. Dilligard? Ms. Simpson, anything you need from me or anything you need to share with Mr. Taylor?
Yes, Judge, but I just need to get this, correct updated address from you, but I'll do that.
Okay, so Ms. Taylor, who is, Ms. Simpson, who is with probation, is going to come talk to you in about 30 seconds. Just to get a better address, we still have got this Ellis Street address, and you've explained that's not a good address.
So like 1440.
You don't need to put it on the record. She's going to come talk to you right back there, and she'll write it down and tell you about how you need to report to probation when you get released. You'll have a certain amount of time before you show up to probation, okay? Good luck, Mr. Taylor. Thank you, everyone.
Thank you, Judge.
All right, so 1 o'clock. I know you wanted 11, but there's too many moving parts to.
Okay, my client will be here at 1.
Okay, let's aim for 1, and position 8 has been reset to Thursday. That's what I got. All right, thanks everyone. Enjoy this bonus long lunch you're gonna get. Did that cover everyone? Yes. You are free to go till 1. Please come back. And I'll mute things in here.
Who?
Steve.
No.
Before we start the final plea calendar, Ms. Wood, can you make sure, please, that, how do you do that? Position 8, Mr. Greer, that needs to move through the conflict channels. It may end up being Ms. Cabrera's case. She said it hasn't hit her desk, so I don't know how that gets pushed along, but this is the first day. He was here. I have his contact information. His mailing address in the system is good, but there are 2 phone numbers and an email address, so we'll get that to whomever. I just don't know how to nudge that along.
I will follow up there, and I believe one of my clients is now should be on here.
Oh.
3 in one calendar.
Is that the global Nokia phone? Mr. Nollie?
Yes, sir. Hello?
Hello?
Yeah. Hello?
You there?
Yeah, hold on. What are you doing?
Hey, well, don't yell. It's all good. It's there. All right.
Yeah.
I see it. You're waving. That's great. It's good to see you. Let me get you a little more on the screen there. Let's see. We missed you this morning. What happened?
I didn't get a notice in the mail.
Okay.
And
let's see what we've got in the system for your mailing address. Yeah, this is an old case. So it's sneaking back up on you. How did you know to call in now if you didn't get anything in the mail?
well, I had got contact from my new attorney. She
What?
called my office. I had my attorney contact me and told me to log in on Zoom.
Got it. Well, thank you, attorney. So I've got an address of Alta View Drive. Is that where you live?
No.
Nope. All right. Well, we'll need to get a new address. You don't need to give it to me right now. You can get it to your new attorney, Ms. Wood, and she will get that into the system. But we are sending notices out to that Alta View Drive address, which I'm assuming was your address way back when. You got arrested in this case in June of 23. So that's almost 2 years ago.
Yes.
Okay. So we'll need to get your new address in the system. We're kind of resetting the process. You had gotten kind of far along in non-complex with a different lawyer and a different judge, but the prosecutors figured out that based on your criminal history, you ought to not be in non-complex, but assigned to an elected judge like me. So here you are. It's all old stuff, but there it is. Ms. Wood, is Mr. Nollie waiving arraignment?
No, Judge, it's my understanding he wants to resolve the case from the plea today.
Oh, my goodness. Okay. Have you and Ms. Dilligard had a conversation?
Yes.
Mr. Nollie, Ms. Wood is telling me, and there's nothing wrong with that, that you are ready to resolve your case.
Yes, sir.
Okay. Well, we can do that. I guess we're sort of ahead of schedule since some folks aren't supposed to be here till 1:30, so I'm happy doing that right now. Are you ready?
Yes, sir.
All right. Hey, Mr. Nollie, can we make one of the conditions of your sentence that you get a new battery for your smoke alarm?
Yes, sir.
Good. I'm gonna add that on there. Okay. Then let's make sure Ms. Rivers is with us. Ms. Rivers, are you good to go?
Yes, I am.
All right. Why don't we all get in various positions? I think you can stay at your tables if you want to be at your tables. We just need, let's do this, boom, and that, and that. Okay. So this is 24 SC 002573. It's position 3 from this morning's plea and arraignment calendar. We have Mr. Nollie appearing virtually. His lawyer, Ms. Wood, is here in court, as is Ms. Dilligard. Mr. Nollie did not get notice of this morning's plea and arraignment calendar because his address had not been updated in the system. He is here now. He wants to enter a plea in his case. Mr. Nollie, before we can get started, I need you to tell me that you're comfortable with this setup. You have the right to be here in open court. You also have the right to have Ms. Wood sitting right next to you, so you could lean over and whisper something to her and she could give you an answer. I can still arrange for you all to speak confidentially, but you just have to raise your hand to let me know you want to do that. Are you waiving your right to be here in open court and also your right to have your lawyer sitting by your side for this hearing? Oh, you don't need to raise your hand. You just need to tell me, yes, I'm waiving those rights.
Yes, I'm waiving those rights.
Okay. All right. Ms. Dilligard's going to get you to raise your hand in a minute. She'll swear you in, and then you'll just need to answer her questions. And you got to let me know that you'll stop me if either you cannot hear what's going on or someone says something that just doesn't make sense to you at all. Will you do that?
Yes, sir.
Okay. Ms. Dilligard, when you're ready.
Mr. Nollie, can you please raise your right hand?
Yes, ma'am.
Do you swear or affirm that any statement or testimony that you should give in the matter currently before this court should be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You can lower your hand. Please state your true and correct legal name for the record.
Jamal Nollie.
Mr. Nollie, are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No, sir. No, ma'am.
Is there any medication that you normally take that you've not taken today?
No, ma'am.
How old are you and how far have you gone in school?
I went to high school, 11th grade, 45 years old.
Do you understand that you've been charged with the following offenses? It's 1 count of possession of cocaine with intent to distribute, possession or use of drug-related objects, and willful obstruction.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent and refuse to enter a plea, then the state is required to prove the charges against you at a jury trial?
Yes, ma'am.
Have you had enough time to speak with your lawyer about all the charges in the indictment, including the facts and circumstances related to the charges?
Yes, ma'am.
Would you like any more time to discuss the case with your lawyer?
No, ma'am.
Are you satisfied with your lawyer's services?
Yes, ma'am.
Counsel, do you waive formal reading of the indictment and any and all defects within for purposes of this plea?
So wait.
Mr. Nollie, do you remember being arrested on these charges?
Yes, ma'am.
Has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty to today? For the possession of cocaine with intent to distribute, the range is 10 years to 40 years. For the possession, use of drug-related objects, and the willful obstruction, it's 1 day to 12 months.
Yes, ma'am.
Do you understand that today you're entering a negotiated plea of guilty, which means the state will recommend the following sentence to the court? Judge, the recommendation is 10 years to serve 23 days balance probated. That's it.
No conditions of probation?
We didn't talk about any. No conditions, Judge.
Okay.
Okay. Is that your understanding of the recommendation?
Yes, ma'am.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes, ma'am.
And do you understand that if there are multiple charges to which you're pleading guilty to today, that the court also has the right to run those sentences consecutively?
Yes, ma'am.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea that you are expecting today, that you have the right to withdraw your guilty plea?
Yes, ma'am.
Are you currently on probation or parole anywhere?
No, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes, ma'am.
Do you understand that if you're on probation, you must follow any special conditions of your probation?
Yes, ma'am.
Do you understand that if you fail to follow any of the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes, ma'am.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that by entering a plea of guilty today, you're waiving any and all defenses, including any mental health defenses?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, the right to appeal if convicted of these charges at a trial?
Yes, ma'am.
Is it your decision to waive these rights and enter a guilty plea today?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes, ma'am.
Mr. Nollie, how do you plead to the charges of possession of cocaine with intent to distribute, possession and use of drug-related objects, and willful obstruction in indictment number 24 SC 002573?
Guilty, ma'am.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes, ma'am.
Do you understand that for a felony charge, you have only 4 years from today to file a habeas corpus petition?
Yes, ma'am.
Judge, if this case were to proceed to trial, the state contends the evidence would show that on June 14th of 2023, officers were patrolling the area of Cleveland Avenue in a marked patrol vehicle when they heard someone call out 12 is coming from the nearby gas station on 121 Cleveland Avenue. Based on their knowledge, 12 is coming infers that police are approaching. Officers pulled into the gas station where the call came from and made contact with Mr. Nollie, who was standing on the driver's side of a parked white car. The vehicle appeared to be in distress as the front fender was hanging off, the hood was popped, and both driver's side and passenger side doors were wide open. Officers approached the vehicle and detected the odor of marijuana coming from the vehicle. Mr. Nollie immediately moved away from the driver's side door, walked to the front of the door, and lifted the hood. He confirmed that the vehicle was his and stated that the vehicle was hot as his reason for being parked in the lot. Officer Johnson asked Mr. Nollie if he had any illegal drugs in the vehicle. Mr. Nollie denied. Officers then asked Mr. Nollie if he smoked any weed. He denied smoking. But he did allow the officers to search the car. He said, "No, you can look." Nollie then, without being prompted, turned out his pocket, spilling the contents of a small plastic baggie containing chunky white substance, later found to be crack cocaine, on the ground. He attempted to kind of disguise it and kick it underneath of the truck, but they were able to obtain it. The drugs were tested by the GBI and confirmed 4.457 grams of cocaine. There were multiple clear baggies within the car, pink in color, small clear baggies, and there was $24 in small denominations. All this occurred in Fulton County, Georgia. Just want to bring to the court's attention that state is aware of this defendant's criminal history. Most of his convictions are from a while ago. I think the most recent one I have is a 2013 conviction. And nothing further from the state.
Okay. Before I turn to Ms. Jackson, is that why you're comfortable with this recommendation that they're all this case? It's all cocaine. There are 5 convictions for possessing cocaine, 4 of them with intent to distribute, but most of them are 20 years old-ish.
Right.
And then the one from 13 is still, that's a decade plus ago.
Right.
But then here we are again with the same thing.
Yes, Judge, that was what made me comfortable with the recommendation was the time that has passed since his previous convictions. I did have concerns with the same charge being back before the court. However, I did take in account the time that has passed since those convictions when speaking with counsel on this case.
Okay. Ms. Simpson, is Mr. Nollie on probation anywhere that you're aware of? Okay, all right. Ms. Jackson, good afternoon.
Good afternoon, Judge.
I'll keep this one simple. For Mr. Nollie, who was on this morning's calendar, can you tell me how many cycles he has?
There were 12 cycles listed in the GCIC.
And the last one? Meaning the most recent one?
The most recent arrest that I have was February the 5th, 2024 in Fulton County for robbery. And that case appeared to be still pending. That case number is 24 SC 003170.
Let's look that up. That was a surprise.
I ain't never had. Can I speak?
I can double check the history, Your Honor, if you.
That's okay. I'll look that case up first. That's a relative of yours, Mr. Nollie. I don't know, it's a relative. Same last name, Tyrek?
That gotta be a relative. That ain't me. I ain't
No, it's not you. This person was born in 98 and does have an open arm robbery. So I don't know, it could be, Ms. Jackson, that the GCICs are tangled up. Do you want to make sure you ran this Nollie versus the other Nollie?
Let me just pull that one up again and make sure, Your Honor. Let me see what they ran.
Okay.
I apologize. My system is just moving slow right now. Yeah.
Okay, well, we'll come back to you. You let me know, because I need to hear from Ms. Wood. So Ms. Wood, why don't you take over for now and let me know about this case and Mr. Nollie and why you think this sentence is an okay sentence.
Yes, Judge. So he was working with one of my colleagues, Ms. Diaco. It looks like the case was progressing through that courtroom. It was on the final plea calendar even. Given that this is a nonviolent offense, if it weren't for the previous convictions, this case would be resolved in non-complex. He also seemingly has been out of trouble for at least a decade. So in the spirit of judicial economy, I would just ask you to accept the state's recommendation.
Mr. Nollie, tell me, are you able to work outside the house?
Yes, sir.
Tell me what you do if you have a job that it's safe for you to tell me about.
I have been doing traffic control, flagging.
Not like up in the tower making airplanes land, but more, hey, you need to change lanes because we're digging a hole in the street.
Yes, yes.
Okay. Tell me what kind of hours you work doing that.
Yes, well, I've been here with my grandkids lately, man. Taking time out with my children, going to work every day.
Okay. How many grandkids do you have?
I have 2 and 1 on the way.
Soon to have 3. And how many kids do you have?
3 girls.
3 girls. Well, that may yield more grandkids. And who stays in the house with you?
Me, my wife, my 3 girls, and 2 grandchildren.
Oh, everyone's under one roof?
Yes.
That's a crowded place. How many bedrooms you have?
4.
4 bedrooms. All right. And do you live in Atlanta or East Point, or where do you stay?
Yes, I stay in Atlanta.
Okay. Does your wife work?
Yes, she's the manager of Pizza Hut.
Okay, so you eat well. And how many days a week would you say that you are out there doing flagging?
At least about 5. We
Okay.
don't work on weekends unless we're doing DOT work. I do that sometimes. I mean, we go in at night and work on the expressway.
Okay.
Out there and work on the expressway, the roadway, stuff like that.
So talk to me about June of 23. How did you get back into business? What was going on? You got all these people depending on you, and for you to get locked up for 23 days took you away from grandkid and kids and all that.
I had relapse, started doing drugs.
Say that again?
I had relapse.
Okay, so some of your sales is related to supporting your habit.
Yes.
Okay. Have you ever received drug treatment?
I have several years ago.
Okay. All right. And was that something you did voluntarily, like you went to treatment, or it was part of a sentence that you got, or how'd you end up there?
It was like voluntarily. Once I had I was in like a drug court. That's some years ago. But
Okay. All right. Do you have any questions about anything we discussed?
no, sir.
All right. Ms. Jackson, any luck?
Yes, but I'm making my notes now, Your Honor, and I apologize to the courts.
That's okay. Do you have a ballpark sense of the most really? I'm just interested in the most recent arrest for Mr. Nollie.
I'm sorry. Just a moment, please, Your
Okay. While Ms. Jackson's working on that, Ms. Dilligard, there's a recidivist notice filed in this case. Are you withdrawing that?
Yes, Judge, I am.
All right. Well, Mr. Nollie, is it Nollie or Nollie?
Nollie, N-O-L-L-Y.
And I know how it's spelled. I just wasn't quite sure how you say it. So Nollie. Mr. Nollie, I find there's a factual basis for your plea, and that your plea is knowing and voluntary. That means you've understood what we've been talking about and no one's forced you to enter your plea. Do you agree with that?
Yes, sir.
I'm sentencing you pursuant to the Probation Options Management Act. And what that means is that while you are on probation, which you're going to be for a minute in this case, if you have a minor issue, let's say you miss a meeting with probation, you and probation will work through that. You don't have to come see me. But if it's more serious, you get arrested for anything, that comes back to me, and I'll figure out what I'm going to do with that. Ms. Wood, can someone in my office sign the indictment for you?
Yes.
And Ms. Dilligard?
Yes, Judge.
Mr. Nollie, is it okay if we have someone sign your name to the indictment indicating your guilty plea?
Yes, sir. Yes,
Pardon
sir.
me? Yes?
Yes.
Okay. All right. Do you have a weapons carry license?
No, sir.
All right. All right, Ms. Jackson, I'm done except for you.
Okay, Your Honor, I'm just pulling it up now. Okay, it was spinning. I apologize.
That's okay.
All right. I see, and I apologize to the courts. I see 41 cycles. The last arrest was November the 2nd, 2022 for driving without a valid license. and that was with the City of Atlanta Police Department.
Okay, thank you.
Yes, sir.
Mr. Nollie, how's your license doing these days?
Yes, I got to get them. They on the suspension right now. But I'm trying.
Okay. So no license for you right now?
Yes, sir.
Okay. How do you get around?
She take me around either Marta or Uber.
Okay. She meaning your wife, who's the manager at Pizza Hut?
Yeah.
Got it. Okay. All right. Well, Mr. Nollie, I will follow the recommendation in your case. I'll let you know this. I hope probation goes really well for you. If we are together soon because you've been picked up for driving with a suspended license or anything to do with drugs, then your probation will change to something that'll be much less interesting for you. And will take you away from your family. So I hope you are in a better situation. Count one, your sentence is going to be 10 years to serve 20 days with a balance on probation. Counts 2 and 3 will both be 20 days to serve. Those will all run together. And I am adding as a special condition of your probation that you submit to a drug and alcohol abuse evaluation. So just in case if you need any additional treatment, if that specialist who meets with you recommends treatment, that treatment will be part of your probation. Otherwise, you're free to do what you need to do. And I'm hopeful that what was going on in your life in 05 and 06 is the old times, and you are ready to be a family guy taking care of all the generations living under your roof. Any questions about any of that?
Sir, no, sir.
All right. So I have here in court Ms. Simpson, who is with probation. She's going to need to get a little information from you. Are you coming up to the podium? You're going to come right there to the all right. You're going to see another person on the screen here. Let's add that. Boop. There we go. That's Ms. Simpson. She's going to ask you a few questions. If you would answer those, she'll end up by giving you your probation reporting instructions, okay?
Okay.
Mr. Nollie, what zip code do you currently live in?
30315.
So your reporting date is going to be April the 14th at 8 a.m. And you're going to report to the 276 Memorial Drive office.
276 Memorial Drive.
Yes, sir.
Okay.
And if you would please, once we finish, can you please email your attorney your current address? I won't ask you to put it on record.
Okay, 276 Memorial.
Yes, Memorial Drive.
Ms. Wood, are you texting it to him? You're going to get a text from your new lawyer, Mr. Nollie. She's sending you that same address. It's about 2 blocks from the courthouse. I know you've been in this courthouse before, and it's just down Prior from, or Central from, except it's Shirley Franklin now, from the courthouse, okay?
Okay.
Don't miss that date, because if you're not there when you're supposed to be there, they send me a warrant and, oh, here we go. We're starting off on the wrong foot. But don't drive there because you don't have a license. Get the Pizza Hut manager to drive you there, okay?
Okay, what the date? She said what day it was?
April the 14th at 8 a.m.
April.
And Ms. Wood's going to text that to you, so no one's going to believe you if you say you didn't know. April the 14th at 8 a.m.
Okay. All right, I got it right down.
Thank you.
You're welcome.
All right, you are free to go. Take care.
All right, thank you, sir.
Thank you, Judge.
Thank you, Ms. Wood. Plea and arraignment. Mute that so we don't hear the smoke alarm anymore. I just need 1 second. So, good afternoon, everyone. We've got a final plea calendar. All the cases that I'm about to call are on the May 8th trial calendar. So if you do not resolve your case today, then you will be back here in court on May 8th for the call of the calendar for trial that week in May. The significance of today is that if you try to enter a plea today and you're unhappy with the sentence you get, you can withdraw your plea, no questions asked. It's like it didn't happen, and your case just goes to the trial calendar. After today, you're free to enter a plea, but you may not withdraw your plea if you're dissatisfied with the sentence you get. That's the main change after today. We will, at a minimum, get on the record what the state's offer is, make sure discovery is where it needs to be, and then each defendant will have a chance to say, I want to go to trial, or I'm going to see if I can do a plea today. With that, position 1 is Benjamin Virgil, except this may not be that way. It's probably Virgil Benjamin. That's correct. Mr. Benjamin. Yes, sir. Good afternoon, sir. How are you doing, sir? All right, Mr. Moore, how are you? Good afternoon, Judge. Good to see you. Good to see you, Your Honor. So what is Mr. Benjamin's announcement, Mr. Moore?
Your Honor, I'm still talking to the state. I was spoken yesterday very late and for also head health reasons I've not been around. However, I think she is new also in the case. As of last year, they sent a discovery to me that went through some other email address, but she didn't send that. I downloaded it this afternoon. Once I get back to my office, I should be able to go through that. However, I was spoke briefly, and if we cannot resolve it, we'll be ready for trial. And
Okay, so you're going to talk a little more today, and then we'll get things on the record. Okay, so Mr. Benjamin, you can take a seat. Mr. Moore is going to speak with Ms. Dilligard a little bit more. And if you all work something out, great. If not, what I'm hearing you say, Mr. Moore, is maybe there was a mix-up as to where discovery went, but you now have it. Given the nature of the charges, you're not particularly concerned that discovery will be overwhelming.
And that would be just our request, well, maybe minor changes in the date of May 8th, Your Honor.
Okay, well, we'll see what happens once you get a chance to look over that.
Thank you, Your Honor.
You bet. All right, position 2 is Ezekiel Stevens, and I think his lawyer is online.
Yeah, good afternoon, Your Honor.
Good afternoon. Let me get a couple of these spotlights off, and you are
Marcy
right
Gold.
there. Nope, I see you. Hey, Ms. Goldman, how are you doing?
I'm well, and yourself, Your Honor?
I'm all right. And Mr. Stevens is in custody. We can bring him out here when you're ready to do whatever we're going to do. what is your expectation as to how we're handling things today?
So Judge, my expectation is we were just served with discovery. He has got 3 pending cases. He's got one that's in the pre-indictment unit and one that was a riot in a penal institution. I'm not sure if Your Honor has those cases or if they've been accused or indicted at this point. The one before you is an armed robbery case that we just received discovery on the end of last week. And I spoke with Ms. Dilligard last night late, and this morning we got our first offer in the case. But prior to that, we were the second attorneys put on this case, and I had filed a motion before the court to allow us additional time to file motions since we just got discovery last week. And I have not had the ability to look over it, and there's some motions that probably need to be filed, and I've discussed some of that with Ms. Dilligard. So that's kind of where we are right now. Our motion to file additional motions was filed with Your Honor, I think March 15th, and we had not received discovery or anything prior to that date.
Okay, I'm looking in the docket here. Mr. Stevens's other cases have not yet been indicted. He has another armed robbery that's unindicted. And then the one you mentioned must be the conduct inside, whether he's at a YDC or at Rice Street. So this case, discovery was served on your predecessor. I'm curious why you didn't reach out to her to
We
get
did.
it. Okay.
So your clerk of court apparently put me in touch with her and sent an email, and then I responded to the email. And I think her response was she didn't know who I was, but my information was on there, and I never received discovery from her either.
Okay. All right. So you are asking for additional time to go through the discovery. And that may yield some motions that require evidentiary hearings.
Yes, sir.
And then that might affect your negotiations with the state. I don't know when the unindicted cases will be indicted. I do know that if there is an attempt to arrange a global resolution, your client, with your advice, could always waive indictment and the state could accuse those 2 cases. I will slow things down in this case so that you can go through that discovery. I'm not going to slow the case down so the unindicted cases can catch up. They'll move at whatever pace they move unless you and Mr. Stevens decide to pull them up to this one by way of waiver of indictment. That's a strategic decision for you and your client to make. How much time would you like? Because I want to issue a new scheduling order that has a deadline for motions to be filed and then a new final plea date and ultimately a new trial date.
Yes, sir. So if we could have about 60 days to review the discovery in the case, it's quite voluminous, and the state did give us a global offer already. I just can't discuss anything necessarily with them before I get some documents regarding those 2 new cases. So Ms. Dilligard and I are, just started talking about everything. So.
Okay. Is Mr. Stevens here? All right, Ms. Goldman, you tell me whether I'm happy to bring Mr. Stevens out so he can hear from me what the game plan is, but I'll let you handle the client management. You may have already chatted with him, in which case there's no need for him to come out here.
No, he does not know about this since all of this occurred pretty much this morning and late last night. We hadn't, gotten in touch with the prosecution yet. I initially thought I was sending emails to another Jasmine in the DA's office. And so when Ms. Dilligard reached out, we realized why she didn't have my email. So that was initially my mistake with respect to her. So she's been quite prompt in getting in touch with me. And we have a lot of things to discuss. So I will go down and speak with my client about, what is going on and his family as well.
Okay, well, if we could get Mr. Stevens out, he can come to the podium, please. So if in the new scheduling order, I set the motions deadline to be about 2 months from now, we'll say early June, do you think that's enough time?
I do, Judge.
Okay. And the rest will follow.
Thank you, Your Honor.
You bet. Hey, Mr. Stevens, come right on up there to the microphone, please. Good afternoon.
Good afternoon.
Your lawyer, Ms. Goldman, is on the screen there. And she and I and the prosecutor on your case were just talking to figure out where we're going to go next. You were brought over here today to do what I thought was going to be the final plea in your case, where it's a last chance to enter a plea where you could withdraw the plea if you didn't like the sentence you received. I was unaware that your lawyer, Ms. Goldman, was just now getting the discovery in your case. She needs a chance to go over that to meaningfully advise you about what your options are. Your situation is a little more complicated than just this case. This is an armed robbery case. You have an unindicted armed robbery case, and you have an unindicted some kind of fight in the jail case. Ms. Goldman's got all those for you, and she'll be talking with you about all those. The only one in front of me is one of the 2 armed robberies. Ms. Goldman is going to see you soon, but she has asked for more time so that she can process all the discovery, police reports, video, whatever there might be. I don't know what's in your discovery. She'll also share that with you, and then you and she will come up with a plan for moving forward. It could be that she encourages you to try to work everything out. She may see some things in discovery that says, gosh, we need to have a motion to suppress. You know, the state says you confessed, but it was the police promised you something they shouldn't have promised you. Who knows? All that I'd hear about from your lawyer and from the prosecutor. But I wanted to bring you out here so you knew why we brought you over here. We're just not able to do the thing I thought we were going to do. We're going to give your lawyer that additional time. She's getting all that information, and then she will meet with you. Any questions about that?
I'm confused.
Tell me what you're confused about.
About that time you said something about time. You said final plea. I don't really know what that means.
What did I? Oh, final plea. Don't worry about it because we're not doing that today. But what we were going to do was this final plea. We're resetting that. So you'll have another chance. Whatever final plea may be, and I'll let Ms. Goldman explain that. We're doing that at another time. Ms. Goldman's not able to do that with you today because she didn't have the discovery in your case. So she's going to get that. Discovery is the information, the evidence in your case. She'll look at that. She'll look at it with you, and then we'll get back together again. Okay? Any questions beyond that? No? Ms. Goldman, what time frame should Mr. Stevens think you'll be able to come see him? Is that in a few days, a few weeks?
So I'm going to call his family and discuss some stuff with them, and then I'll probably be down to see him in the next 2 weeks, one of these weekends, not this one, next weekend.
Got it. So she'll speak with your family, then she'll come see you, and by then she'll have looked through the evidence in the case that's been indicted. All right? Okay. Yes, ma'am.
Hi, good afternoon, Judge.
Hi.
I'm Ezekiel's mother, and I have my family here with him, and we have youth ministers and everybody to support Ezekiel. Please forgive me for my emotions.
This is your little boy. It's okay to be emotional.
My son has been incarcerated since November 13th. And I'm just asking, is it possible that he can come home until that next court date? Or can something, I haven't.
So you should talk to Ms. Goldman about that. We did have a bond hearing when a different lawyer was representing Mr. Stevens, and a number of things came to light after that showed that bond didn't work real well for Mr. Stevens. He's got 2 new cases. That makes bond release kind of complicated. But you should talk with Ms. Goldman about that. And she mentioned she's going to be calling the family, and it may be that she and you all decide that she ought to file another motion seeking reconsideration of the bond situation.
So Judge, not to interrupt you, we did do that and we were removed from your calendar as we were told that Your Honor was not going to consider bond.
Okay, that was interrupting me, and you can do that again, and I guess you'll find out what happens. But I want to encourage you, are you Ms. Stevens? Different last name?
Ms. Meadows,
Ms. Meadows. I want to call you by the correct name. Ms. Meadows, you should talk with Ms. Goldman about that. She'll tell you what she meant by what she just said and give you her sense about what to file or not file. How old are you, Mr. Stevens?
17.
I'm a 17-year-old. I would be hurting everywhere if he wasn't at home with me. So I understand your emotion. I have to be careful not to react just to emotion. What mom wouldn't want her young son home? I have to look at all the other pieces as well. And there's some pieces for Mr. Stevens that they're not pretty pieces right now. He has a great lawyer representing him, and she's going to try to clear some of that up. I need to give her the time to do that, because what I have on paper only, and there's more life than just paper. Paper only is that bond didn't go well for Mr. Stevens, and that's not your fault. It is where he ended up. So I'm saying no for right now. I'm not saying no forever, but I'm trying to move this case as quickly as is consistent with your son's due process rights. Ms. Goldman, it's not her fault, but she is slowing things down. She has asked for 2 months. That's not the court saying, I'm not ready to go. Most importantly, it's not the state saying, I'm not ready to go. And so those 2 months are on the defense team. If those 2 months pass and all of a sudden the state says, oh, we're not ready, or we don't have this witness, then we ought to talk about bond again. But between now and then, that's a defense request, not the court's too busy to see Mr. Stevens, or the state says they're not ready to move forward. There's always a chance to get in here sooner if what it looks like is there's a way to resolve all these cases. But I don't want to rush any of that, and I very much appreciate Ms. Goldman giving a realistic set of deadlines, because she could have said, how about I'll try to be ready in a week? And then she's not, because there's a lot to process, and your son's case is important. And so she is conservative in her estimates, and that works better for everyone, so that she's not coming back each week saying, I need a little more time because I need to do X, Y, or Z. If something can be done sooner, we can always get back together sooner. But Ms. Goldman is building in a realistic time frame so that when we're next together, she is ready to go with whether it's a motion to suppress or another bond motion, or, hey, we've worked it out. So that was a lot, but I want you to understand what I'm balancing as well. And I appreciate you being here, and it tells me a lot that there are this many people here for Mr. Stevens. He has a support network. What he does with that ultimately is up to him, but I also appreciate he's 17. My son is a knucklehead, and he can't be trusted to always make the right decision. And I think you're in the same situation. So I appreciate you sharing what you shared. Okay. Mr. Stevens, any other questions?
Yeah.
What's that?
You said 2 weeks, and then you said 2 months.
So I don't know about the 2 weeks. Oh, Ms. Goldman is going to come see you in 2 weeks.
All right.
She actually said it. I didn't, but she said she'll see you within 2 weeks. Probably 2 weeks. Could be next weekend, but probably the weekend after. So 2 weeks from now. The 2 months is how much time Ms. Goldman has asked for to get all the discovery, figure out what to do with it, make important legal decisions on your behalf, meet with your family, probably meet with you again, and then let me know what's next for Ezekiel Stevens' defense. So both things, 2 weeks, you see your lawyer. 2 months, you see me, okay?
2 months, I see you.
If folks are ready to go, if not sooner, okay? Thank you. All right, Ms. Goldman, keep us posted. If you're not getting what you need, just shoot an email to me and Ms. Dilligard, and I'll make sure that it happens.
All right, thank you, Judge. May I be excused?
Yep.
Thank you.
Thank you, Your Honor.
You're welcome. Broderick Leak. Hey, Mr. Leak. I'm all right. Ms. Wood, what's happening with Mr. Leak today?
Just a final hearing, Judge.
All right, we ready to do that? All right, Mr. Leak, if you'll come on up to the podium with Ms. Wood, please.
Yeah, you're welcome. You guys get started first. Yes, thank you.
So we're going to start in just a second. Ms. Clark, there is a Ms. Jones on Zoom who wants to speak. I'll engage with her when we're done. This really isn't a forum for there to be a whole lot of speaking, but I don't ever want to tell a relative of an alleged victim that that person won't be heard. I just didn't want you to be surprised that she's here. Okay? All right. Let's get on the record. This is 24 SC 004712, State versus Broderick Leak. Mr. Leak, this is your final plea date. I'm going to find out from Ms. Wood if she's got all the discovery she thinks is out there. And then I'll have Ms. Clark, the prosecutor, put on the record what the state's offer is. And then you're going to let me know what we are going to do with that. But before we dive into that, I noticed that you may have a new case as well, which is always a surprise. You do. You've got new charges. Involving marijuana. So I'll need to work through how you still have a bond in the case we're talking about when that happened, but we won't do that today. All right. Ms. Wood, tell me about discovery in Mr. Leak's case.
I think I have everything, Judge.
Nothing jumps out at you as missing.
No.
Okay. Ms. Clark, are you aware of anything pending in discovery? In other words, you're waiting for it too, so Ms. Wood wouldn't have it.
There is nothing, I think, that's pending in this case, Your Honor, for discovery. I do believe that it's complete. And I know it was served on March 24th.
Okay. Well, Ms. Wood, if something comes up, let me know.
Thank you, Judge.
What is the state's offer, Ms. Clark?
Your Honor, the state's offer for count 1, child molestation, is 20 years, 5 to serve in confinement. For count 2, child molestation, 20 years, 5 to serve in confinement, balance probated. And then for count 3, enticing a child for indecent purposes, 30 years to serve, 30 years, 10 to serve in confinement, balance probated. Defendant, after confinement, would need to register as a sex offender, remain away from the victim child, and not be around any child under the age of 18.
Okay, so the total math would be 30 to serve, 10 balance probated. All those run together.
Yes, Your Honor.
Okay, all right. It was a little complicated to me, Mr. Leak, but I think I get that if you were to plead today, what the state would recommend is a sentence of 10 years in custody, followed by 20 years on probation. That's the 30 serve 10. You follow that?
Yes, sir.
Okay. Is that something you're interested in pursuing today, or would you prefer that I move your case to the trial calendar?
We can move to trial.
Okay, we'll do that. That's the May 8th trial calendar, which is 1 month from today. So Ms. Wood, I guess I'll need you to let me know if there are discovery issues as you go through what you very recently received.
Yes, Judge.
Okay. Let me check one thing, Mr. Leek, about your bond. Your bond is old. And do you still have an ankle monitor?
No, sir.
We took that off?
Yes, sir.
You took it off, or some judge said you could take it off?
I was in Fulton County on the new case that you talking about.
Oh, they took it off?
Yeah.
And you didn't get it back on? Okay.
If I may, the Odyssey is showing that he's got a court date for an ankle monitor compliance calendar, it looks like. I think that's what that calendar is. It's on the 14th.
In this case?
Yes, in this
Yeah,
case.
compliance hearing 8H. I'll manage that.
Okay.
You don't need to go to that. I'm gonna get you off that calendar. You don't have an ankle monitor anymore.
Thank you.
And so it was removed at the jail.
Yes, sir.
If the county is looking for the ankle monitor, it would be with the sheriff.
Yes, sir.
Okay. All right. Ms. Wood, anything else?
No, Judge.
Okay. Ms. Clark, anything else?
No, you are.
All right. Thank you. Mr. Leek. But I want to talk to you about your bond. You are supposed to stay away from Kaylee Jones and her mother. And in fact, no contact with any kids under 18 without supervision. You are managing to comply with that?
Yes, sir.
It's been the case for a long time, given how old this bond is. Okay. Before you go, Ms. Jones, was there something you wanted to add?
I just wanted to come here to speak up for my daughter because it's been a while since the case. I wanted to let you guys know how it has traumatized her, how it still affects her to this day. She was 10 years old when this happened. You can only imagine what a 10-year-old seen with her own eyes, and then after called a liar. And I'm not stopping until he's in jail because he needs to be in jail for what he did to a child, and you took advantage of her love for you. It was never a problem with y'all, and this is something that I feel like he planned on doing for a while because, it just happened out the blue. So I just feel like I will be at every court day, every trial day, everything to make sure that justice is served for my daughter. And since she's not here with me right now to speak for herself, I will be the speaker for her until justice is served. She needs justice, and I feel like nobody's taking serious enough. It's been 2 years already, and he's still out doing whatever. And she's traumatized. Is still traumatized to this day. She don't want to be around men. Her granddaddy, nobody. She don't want to be around. She's uncomfortable around men. He took that away from her at a young age, and it's not fair.
All right, Ms. Jones, it's important that you were here today. I appreciate you sharing that. You should get notice of all future court dates. There shouldn't be too many, and what's left is trial. So on May 8th, Mr. Leek will be back here. That will not be the day of the trial. That's a day where we simply call the calendar. So you'll be welcome to be in court or appearing virtually, but I want to manage your expectations. The only thing that would happen on that day would be if everyone has worked something out, there would be a plea then, but that's not actually when the trial starts. That's when we figure out who's ready and we determine the order in which we're going to try cases. But if you got notice today, then you'll get notice each additional time that Mr. Leake's case is on one of my calendars, okay?
Yes, thank you, and I will be at every single one of them.
All right, well, you'll be most welcome here. I appreciate you dialing in.
Thank you, I appreciate you.
All right, take care. All right, Mr. Leake, you are free to go.
All right, thank you.
You bet. Next is Victor Okoro. Come on up, Mr. Okoro. Your lawyer is on the call. He is, he's still here. Mr. King. Hey, Mr. King, we're ready for you. Tell you what, Mr. Okoro, I'm gonna go to the next case.
Yes, sir.
And when Mr. King returns to his virtual appearance, we'll get you up here. So take a seat.
Very well, sir.
Thank you. How about Tariq Thomas? Hey, Mr. Thomas, I saw your.
Good afternoon, Your Honor. I'm standing in for Mr. Benshita. He's out unfortunately with an ear infection. So I'll just be standing. Yeah, for purposes of today, I'll be standing in for him.
Certainly. Appreciate you being here. Sorry,
Not a problem.
someone wants an earache. That's terrible. So we're going to talk about position 5 now. It's 24 SC 004822, State versus Tariq Thomas. Mr. Thomas is here in court. We have Mr. Olaloye, who is filling in for his colleague, Mr. Benshita, and this is final plea. Hopefully, Mr. Olaloye, you're in a position to announce about discovery. Any reason to think Mr. Benshita does not have discovery in the case?
No, Your Honor. It's my understanding that he does have all the discovery.
Good. So you're ready to move forward with the case, or he is, if the case is not resolved today.
That is correct, Your Honor.
All right. Ms. Clark, any discovery you're waiting on?
No, Your Honor.
All right. What's the state's offer in this case?
Your Honor, the state's offer, is 2 counts of cruelty to children in the first degree. The state's offer is 20 years to serve 10 in confinement, balanced, probated, with the special condition of no further contact with the named victim and not being around, not having any unsupervised contact with any minor child under the 18 years of age, a mental health evaluation, and also a family violence intervention program.
Okay. Someone is unhappy back there. Okay. All right, Mr. Thomas, I understood the state's recommendation to be, if you wanted to enter a plea today, the state would be recommending 20 years to serve 10 in custody, followed by 10 on probation with the conditions that you heard. Did you understand the state's recommendation?
I did, Judge.
Today, you could enter a plea. Mr. Olaloye wouldn't have to agree with that. He could advocate for something different. If I were to sentence you to more than what Mr. Olaloye asked for, I'm making it up, but let's say he said, no, Judge, it should be 5 years to serve 2 with a balance probated. If I went higher than that, you'd be able to withdraw your plea. After today, you may still end up reaching some understanding with the state and want to enter a plea. You just don't get to withdraw that plea if you don't like the sentence you get. Do you understand that?
Understood.
Okay. Are you interested in pursuing the state's recommendation today or having me move your case to the May trial calendar?
Rather my case be moved to the May.
Trial calendar? Okay. And you and Mr. Benshita have been in good contact with each other?
Yeah.
Good. Okay. Stay in contact with him. You'll need to be here and he will be here, assuming his ear is better, on May 8th, and we'll figure out in what order we're trying the cases. All right?
All right. Thank you, Judge.
Mr. Olaloye, anything else on behalf of Mr. Thomas?
Nothing else on behalf of Mr. Thomas, Your Honor.
All right. Mr. Thomas, you're good to go. Thank you.
Thank you.
Your Honor, that concludes my matters. May I be excused?
Yes, sir. Thanks for filling in.
No problem. Have a good one.
You too. Ms. Nelson, would you shoot an email or something to Mr. King, see if we can get him to turn his phone on? In the meantime, Lauren Scott. Ms. Rios? Oh, Ms. Scott's right there. She just stood up slowly.
I'm sorry.
That's all right. Then you don't need to apologize. I was wondering where your lawyer didn't seem concerned at all. She knew you were here.
I wanted to have a few minutes to talk to Ms. Clark
Okay.
before we do the final plea.
Got it. Ms. Scott, you can sit back down. Ms. Rios is going to talk with the prosecutor a little. You sure can. You go do that. And when Ms. Rios has had a chance to talk to the prosecutor, we'll get you back up. All right. Anthony Johnson.
I think he's on Zoom though.
Yes, he's listed as Yvette Johnson. All right, let's get him there. And let's get you there. All right. Ms. Wood, what are we doing with Mr. Johnson today?
Judge, it might make more sense to preserve final plea rights. Mr. Lagarde and I are working on this one, and Mr. Johnson and I met yesterday, and then after I spoke with him, I got some new information from Mr. Lagarde. He's got at least one unindicted case that's similar to this one. So we're looking at a global resolution. If we could leave it on the May trial calendar, I think we'll have something ready to go by then.
All right, do we have a PI number?
Yes, Judge, it's, let's see. It's a CP number, 23 CP 224047.
Okay, gosh. So that may be older than,
And there,
there's another PI.
Yeah, and then there is a PI.
oh, okay.
24 PI 001035.
001
001035.
35. Got it. Okay. So why don't we do that? So Mr. Johnson, all that Ms. Wood has asked is that I preserve your final plea rights because she and the prosecutor are still seeing if maybe there's some way to work this out. This being not only the case you've got with me, but one or both of your unindicted cases. Okay?
Okay.
So you'll be here, not on the screen as Yvette, but you'll be here are you in Georgia?
Yes, sir.
Okay. Yeah, you'll need to be here on May 8th in person.
Okay.
So we can have whatever conversation we're going to have about your case. I will be ready then to get that update. And we'll preserve your final plea rights, meaning if you guys are pretty close and you want to try a plea on May 8th, and your lawyer's recommendation is going to be a little different from the prosecution's, you can still go forward with it. And if you don't like the sentence I impose, you could say no thanks and no problem. We'll just put you straight onto the trial calendar. Okay?
Okay.
Any questions about that?
No, sir.
All right. Ms. Wood has your contact information. She knows how to find you?
Yes, sir.
Okay. If that changes, let her know, and we'll take it from there.
Okay.
All right. You're free to go.
Thank you, Judge.
You bet. All right. Mr. Drabick will be here on, maybe virtually, but on Thursday. That gets us to Shamir Ferguson. Hey, Mr. Ferguson, come on up. Ms. Charles, I think this is your case.
Judge, if I could just have a moment, I need to speak with Ms. Charles and Ms. First.
Okay, time out. We'll do this in a moment. You guys will talk, and there's someone online. Ms. Forbes is, okay, she's here, so you know, and if it's appropriate for me to hear from her, I will at that time. But you three should talk, and we'll come back to this one. How about Cameron Hill? Mr. Hill is here.
Also, Judge, I need to speak with him. We're gonna try to work this one out today.
Good plan. All right, Mr. Hill, Ms. Wood will talk to you after we get through this calendar, which has only one more position. Jason Nickerson. Mr. Nickerson is here. Also, Ms. Wood.
Yes, Judge. I think this will just be a final plea hearing, but I also need to speak with him briefly.
Okay. Let me make sure I didn't, so we've got Mr. Benjamin, but Mr. Moore and Ms. Dilligard are going to speak briefly. And then we need to get Mr. King to appear, and that'll get Mr. Okoro. And then everyone else is, people need to talk a bit. So why don't you do that? I'll come back out in a few minutes and we'll start with whoever's ready. Thank you. I'll mute the audio. All right, let's see if we can move some of these other cases along. Starting from the top is Mr. Benjamin. Mr. Moore, did you and Ms. Dilligard get a chance to speak?
Yeah, Judge.
And
Based on the little issue that we have with the discovery, we would have to be that we have some more before it. However, if we can resolve this case before that, I will ask all of the chambers maybe to put in the calendar or something else, Judge.
sure, no, we've got a whole month. So if I'm making it up 2 weeks from now, you sort something out, you just let Ms. Nelson know and we can bring Mr. Benjamin in. Do you feel, Mr. Moore, like you'll have enough time to be ready? Again, May 8th is just the call of the calendar. The trial wouldn't be for another week or so. But I know there was a hiccup in discovery. Do you feel like you'd be ready to go forward, or can I keep it on the May 8th trial calendar?
We just keep it on the May 8th, correct? If I have any issues, especially with the little time to sort about the discovery, and that's some visual and audio that I involved also, if I'm correct, then we'll be able to resolve that. If not, we'll be ready for trial, Judge.
Okay. So are we preserving the final plea rights? Because it's sort of too soon to say that's a fair offer or not a fair offer. So move it to the trial calendar, but preserve Mr. Benjamin's final plea rights.
That's correct.
Okay, that makes sense to me. Any objection to that, Ms. Dilligard?
No objection, Judge.
All right, Mr. Benjamin, do you have any questions about what we're doing?
No, sir, Your Honor.
Okay, well, you stay in touch with Mr. Moore, and I will see you again here in court, maybe with those same coveralls on May 8th, okay?
Yes, sir.
All right, thank you both.
Thank you, Judge. May I be speaking?
Yes, sir. How about, I meant to ask Ms. Nelson before I came out here. Oh, Mr. King, are you back?
Judge, I'm here.
Yeah, well, you were always listed as being here, but we took turns calling out your name, each person in court, and you didn't hear any one of the 17 people in court.
I'm going to be honest with you, Judge. We're having some technical difficulties. I'm over here in the Caribbean, and it's been difficult. So I'm glad to be in front of you, but we got some issues going on.
Okay, well, I'm impressed you brought a bow tie to the Caribbean. Mr. Okoro, why don't you
Yes, sir. Yes, sir.
come on up to the podium, okay? All right, we've got Mr. Okoro, we've got his lawyer, Mr. King, and we've got Ms. Clark add there. So can you just move the screen a little bit so that way Mr. King can see you? There you go. Perfect. Okay. Let's go on the record in 24 SC 004749. Mr. King, have you received discovery in your client's case?
Judge, I received discovery. I'm still going through it, but I've received it.
Okay. And is your sense, I know you're still going through it, but so far is your sense that that's complete discovery?
I honestly would have to go defer to the state on that. I'm not sure.
All right, Ms. Clark, are you aware of anything missing from discovery? Not meaning you withheld something from Mr. King, but you're waiting on something from GBI or some other source?
The only thing on this case, I was listening to an audio, and it seems that the victim's mother provided a bank statement to confirm that they had actually rented and got a hotel room. So that I'm actually have put in to get that. I know that that is outstanding. As soon as I get it out.
Okay, but it's a bank statement showing that a hotel room had been paid for?
Yes, sir.
Okay, well, as soon as you get that, obviously turn that over to Mr. King. That's something that you think is in police custody, or you're reaching out to the bank? Because if you're reaching out to the bank, Mr. King can get to the bank in the same way you can get to the bank?
No, it's something that I'm actually waiting to speak with the victim's mother about.
Okay,
Because the detective says that she doesn't recall it being sent to her.
okay, but the mother referenced it.
Yes, Your Honor.
Okay, well, we'll see what comes up. All right, what is the state's recommendation at this point, Ms. Clark, for Mr. Okoro?
Your Honor, for the single count of child molestation, the state's recommendation is 20 years to serve fine and confinement and the balance on probation.
Okay, Mr. Okoro, you understand what the state's recommending in this case? 5 years in custody followed by 15 years on probation.
Yes, Your Honor.
Okay, are you interested in going forward with a plea today, or do you want your case to move to the trial calendar?
Trial calendar, Your Honor.
All right. I think, and Mr. King, you would know this hopefully by now because it got to you. I think Mr. Okoro may also be on the Judge Emerson consolidated calendar. Does that ring a bell?
Judge, I did see that. I just wanted to say this. I'm not available on the 23rd and the 24th. So I would ask that be taken off of that. But besides that, yes, I saw it as like position 40 or 50 or something like that in the consolidated. But I would ask for that to be taken off of that because I have a personal issue that I'm not going to be available on the 24th, the 23rd and the 24th.
Okay, couple things. One, of course, you'll be able to attend to the things you need to tend to. Two, I think that calendar is the week of the 21st and the 28th.
Right. And I filed an emergency medical leave for the 23rd through the 28th.
Oh, well, that conveniently takes up both weeks.
Yeah, I mean, this is not an old case, Judge. So I don't necessarily know if we need to be worried about it. You know, and so, but you know, I got some. It's not even. It's I'm just I got some things I need to handle with my family.
Okay, got it. I will figure out how to handle that situation, but it sounds like the May 8th date is not problematic for you.
Correct.
Okay. Then, Mr. Okoro, we are moving your case to the trial calendar. You and Mr. King may continue negotiating with the state. There may be some other situation where you want to enter a plea, and you're free to do that. You just don't get to withdraw your plea if you're unhappy with the sentence anytime after today. Okay?
Understood, Your Honor.
Ms. Clark.
Your Honor, I wanted to add, so for the May 8th trial calendar, the state would be filing a motion for the initial outcry witness to appear by Zoom. She was actually diagnosed with tuberculosis and her daughter is recovering. So she's about to get out of the hospital, but of course, obviously they would likely not be able to because they're both still contagious.
Yeah, they're not coming in here.
Yeah, I know. So I would be filing a motion so that they could, the mother could appear by Zoom.
Okay, and this is a witness to whom the alleged victim initially outcried.
Yes.
Is it her mother or it's a person to whom she made an outcry?
Oh, it is her mother.
This is the same person who maybe is getting you this hotel receipt.
Yes, sir.
Okay, and this is the person who is recovering from tuberculosis, not the alleged victim.
Not the alleged victim.
Okay, so of your universe of witnesses, there's just one that it would make sense to have as a virtual witness.
Well, it would actually be two. So the mother was the initial outcry witness, but her sister was present when she disclosed to the mother.
Okay.
And the sister was also in the bed when this incident happened.
And sister is mixed up with the tuberculosis as well.
She was the one that got it first and I think gave it to mom.
Okay. All right. Well, file that, and at another time when Mr. King is not in the tropics, we'll work through how we might navigate that. Okay. All right. Thank you. Mr. King, anything else?
Nothing from the defense. Judge, I'm like I said, I'm still going through discovery. This discovery was served by the DA's office on on March 21st. And and I don't say that with any ill will, but our our scheduling order said it was supposed to be served in January. And as long as we have the opportunity to go through it and do what we need to do, I don't have a problem. You know what I'm saying? But
I do know what you're saying, and you're not the first to have bumped into that today. And my response will be consistent, and that is, if you identify things that need to be litigated pre-trial, we will make time to do that. So I would never say, it's too bad, you got discovery late, we're not going to do this motion to suppress. My only request is you do what you do, which is be diligent, and not right now because you're on break, but when you're not, you go through, and if you identify something that requires a motions hearing, the sooner you let us know that, the sooner we can say, all right, we got to take this off May 8th and find a window of time when we can have that hearing.
we'll do. I mean, listen, we respect both sides of the issue. So, I just wanted to make sure that, that was said.
Okay, appreciate it. Mr. Okoro, any questions about anything we discussed?
No, Your Honor.
Okay. Yes, Ms. Clark.
Your Honor, I wanted to add, my predecessor actually did share the evidence.com link with Mr. King on December 1st, 2024. But since I saw that the certificate of discovery had not been filed, I had my legal assistant to reserve it. So defense has actually had discovery since December 1st of last year.
Okay, well, I don't want to get in the back and forth. I trust Mr. King won't tap the brakes on this case unless he absolutely needs to. But if he does, because that's in his client's best interest, we'll do that. And while this case isn't all that old in terms of the date of the indictment, it is old in that the alleged incident, or at least the arrest, is from March of 2022. So it's definitely time to move this along. I want to look at your bond order to make sure there's nothing here we need to talk about. Oh, so you've had this from the get-go, Mr. King. You're on the bond order.
They hired us from the very beginning. So
okay.
We've been on it from the very beginning, and happy, represent this young man, and we're here, and
Okay.
we're gonna see it through.
All right. Nope. The main condition of your bond, Mr. Okoro, is that you have no contact with the alleged victim. So as long as you're doing that, for now, you're all set.
Here to go.
Okay. Thank you. You can go.
Yes, sir.
Thanks, Mr. King. Back to the tropics.
Thank you, Judge. May I be excused?
Yeah. Go get the drink with the umbrella.
Yes, sir. Yes, sir. Take care.
All right. As long as that's consistent with the medical leave. All right. How about Lauren Scott? I don't see her in here anymore. I bet she didn't flee, though. Did she just step out?
I think she's probably I think she's probably.
Okay. All right. Then Shamir Ferguson?
Ready.
Ready. Come on up to the podium, please. And Ms. Charles, do you know, is Ms. Forbes wanting to be heard during the course of this, or she is simply listening in, as is her right?
Listening in.
Okay, got it. Okay, let's get on the record with position 924 SC 005143, State versus Shamir Ferguson. Ms. Wood, how are you doing with discovery?
We have discovery. Ms. Charles and I are looking for a cell phone extraction that we think exists.
When you say looking for it, I mean, like, you're not just going to find that on the ground.
Yeah, we believe that law enforcement did do an extraction. It's not in the current file. I spoke to Ms. Woods, and the defendant confirmed that his father had changed his password, so we reached out to the lead. So we can get that done. I believe based on conversations with the victim and Ms. Wood and the defendant present, they are going to be pivotal for the case.
The cell phone extraction?
Yes, their message is that.
Is it one phone that needs to be extracted or multiple?
It's just the one.
Okay, and it's Mr. Ferguson's phone, which you have.
We have the phone in evidence. I don't know if the extraction was done. He seems to believe it was done, but I don't have it in the physical file. So we're trying to get confirmation whether the extraction was done. If it wasn't done, we need to get it done.
Okay, but you have the phone and you have a password, so you could get it done if it hasn't been done. But we have to get in line for an extraction, or is that something your office can do?
I think we have the capability to do it, but I'm going to confirm.
Okay. All right.
The victim has confirmed that the messages what he referenced did exist. She herself has copies, so she's getting me her copies. And then we'll do the timeline and we'll figure out the best for this case.
Okay. What does that mean for May 8th? Would there be an extraction done by then if there hasn't been one already?
Do you want to commit to that? I think you do. At least be underway by the
Okay, I don't know how much underway helps the state. It may be that Ms. Wood now really wants to try the case tomorrow because you don't have the extraction. Right. What are your thoughts about how we manage that, Ms. Wood?
Judge, we want that extraction.
Oh, you want it too?
Yes.
Okay.
Yes.
Then we're not in a oppositional state when it comes to, let's leave this on that May 8th trial calendar. Let's preserve your client's final plea rights because the extraction might turn one side's world upside down or the other's, evidentiarily. If we're getting, well, I guess we all will be here May 8th and we'll just get an update. But I'll tell you, if you know on May 7th, the extraction's not done, but it'll be done soon, but it doesn't make sense to drag everyone in here. Are you local or do you have to come from far away?
I'm local.
Okay. There's no need to drag people in here on the 8th. If this is a case that can't go forward, there's no GBI work that needs to be done on a DNA side or anything? Okay. It's just the extraction. Okay. Then my proposal, Ms. Wood, is that we preserve Mr. Ferguson's final plea rights. For now, keep it on the May 8th trial calendar, and we just check in to see how that extraction, either it's located because it's already been done and it's handed over, or one is finally done.
Yes, Judge.
That works?
Yes.
Mr. Ferguson, any questions about that?
No, sir.
All right, your bond.
What's that?
I sent an email. Look at it whenever we get done. I'm just trying to get you in my office.
All right, that's
Yeah.
all.
So your bond says no contact at all with Ms. Forbes except for child support payments. Stay out of trouble, no guns. Are you taking care of your child support obligations?
Yes, sir.
Okay. And otherwise, you're having no contact with Ms. Forbes?
Correct.
Good. Keep that up. That's how it needs to stay. And it doesn't sound like you've heard any concerns from Ms. Forbes that the bond is not being complied with. Okay. All right. I'll see everyone on the 8th unless we have to push this down the road a little bit because of the extraction.
Thank you. And then after 6 weeks, it's done?
Yep.
Just check your email and respond back to my.
Okay.
How about Mr. Hill? Is that ready to go?
I'm not ready to go. I'm still working on that one.
Okay.
We can handle Mr. Nickerson finally.
He stood up like he's ready to go. All right, Mr. Nickerson, come on up, please. All right, this is 24 SC 005550. Mr. Nickerson is here with his lawyer, Ms. Wood. Ms. Dilligard has the case for the state. Ms. Wood, status of discovery.
I think
we have everything except the only thing that's potentially missing is fingerprints. Do you have anything? I don't, they're not gonna make or break the case, Judge, but there was mention in the police report about some prints being taken.
Okay.
I don't have anything in my file, but I can look into it and.
Do you know if it was APD prints versus GBI prints?
I believe the reports at APD listed the print,
Okay.
but I will inquire about that today.
Okay. All right. Let everyone know. But beyond that, it sounds like that's, as you said, not make or break. You feel like you've got everything.
Yes, sir.
Okay. Ms. Dilligard, what's the state's recommendation in the case?
For this case, the offer is 15 to do 10
All right. 2 armed robbery.
to armed robbery.
Okay. Mr. Nickerson, the mandatory minimum for armed robbery is 10 years to serve. So the state's recommending the minimum. But armed robbery is a non-parolable offense. So if you were to enter a plea to the indictment as it stands, the state would recommend the minimum, and I would be required by law to sentence you to 10 years in custody, and then at 5 years probated, one of your counts, it has to run consecutive. I'm seeing you shake your head. You're getting a little bit ahead of me. First, do you understand what the state's offer is?
Yes, sir.
Okay. Is that something you're interested in pursuing at this time?
No, sir.
Okay. You'd prefer that we move your case to a trial calendar?
Yes, sir.
Okay. Then I will do that. If between now and May 8th, Ms. Wood, something comes up where we can get this case in here, let Ms. Nelson know. Otherwise, I'll assume folks will be ready with the one caveat about fingerprints to move the case forward. Mr. Nickerson, any questions about anything?
Yes, sir. Maybe would I get a chance to look over the evidence?
Yes, that's a great question. And the person standing next to you has the evidence, not the originals, like I'm making this up, but if there was a gun recovered, Ms. Wood doesn't have that gun, but she'll be able to tell you there's a gun, here's a picture of it. But if there's body cam, for example, officers interviewing someone, Ms. Wood would have that, and she can make it available for you to listen to.
Street camera, sir.
Whatever's been turned over. If Ms. Wood doesn't have it, she can't share it with you. But Ms. Dilligard's not holding on to anything. The only thing that may still be out there that I'm aware of is results of fingerprints that may have been lifted from who knows what, the side of a car. There's a carjacking alleged. And if they were able to make any matches, that it were your fingerprints or Ms. Wood's fingerprints or whomever's. That hasn't been, but everything else that's in discovery, Ms. Wood has, whether it's surveillance cameras or cell phone records or whatever. Well, let me look at your bond. Are you still wearing an ankle monitor?
Yes, sir.
Okay. All right, Ms. Wood, help me remember if we don't reach this case on this calendar to talk about the ankle monitor.
Yes, sir.
Thank you. All right, keep the ankle monitor charged.
Yes, sir.
Thank you, Judge.
You bet.
I'm gonna step out and talk to Mr. Hill in this part.
Okay, it looks like maybe we can pivot to Ms. Scott.
Yes, Your Honor. After talking with my client in this park, I'm gonna ask for a reset to keep her final plea rights intact. There's some litigation things that Ms. Park is asking for that I'm gonna try to get to her that might change what she's offering.
Okay, when you say reset, could we not move?
Keep it on the trial.
Okay, so we'll just, Ms. Scott, your case is still on the May 8th trial calendar, but we'll preserve your final plea rights. And between now and then, it sounds like there's some information that you could help Ms. Rios get, that she'll get to Ms. Clark, that might cause Ms. Clark to think about this case in a different way. Is that what you two were talking about? I'm asking you, yep.
I'm sorry.
Yes? Okay. Do you feel like you understand the kind of information Ms. Rios is interested in? Okay, all right. Any questions about anything, Ms. Scott? Ms. Rios, anything else? Well, how about discovery? I know you'll be getting some reciprocal discovery, but do you feel like you've got everything that you're expecting to be in the state's file? Okay. Ms. Clark, anything on Ms. Scott's case?
Your Honor, the only thing I saw is that the medical records, I know we have, the medical physician report, but I want to, see if, in my opinion, it doesn't seem that the records we have are complete. So I put a request in to see if it's something more, and I will hand that off to Ms. Rios. But I could be wrong, I just want to make sure that, because it just looks like it's a report from one physician, but it just seems that the admission and when the child was there, that information is not there.
Okay, so do you think it's supplemental or that there are going to be medical reports that take this case in a different direction?
No, Your Honor, I think it will just be supplemental.
Okay, all right, well, the sooner you can get that, the better. I'll note that that's something that in theory Ms. Rios could be trying to get as well, not because she should, but this isn't something that is exclusively in the state's control, but the sooner you can get that, if it exists, the better. And it sounds like Ms. Rios, you'll be working on the mitigating information. Yes, ma'am.
Do I have to read it here in person?
On May 8th?
Yes.
Yes, you should be here in person on May 8th. Ask Ms. Rios again as we get closer to that date. If for some reason she knows this has to be reset, then you don't have to be here. Is it a problem to be here in person? You don't, where do you live? Oh, okay. We'll talk with Ms. Rios about that and she can reach out and we'll figure that out. If on the 8th, all we're doing is making sure everyone's ready to go, you can appear, where's Baytown?
45 minutes outside Houston.
Okay. You could appear virtually for that. If you are entering a plea to anything that's not a misdemeanor, you will need to be here in person. But we're not there yet. So if on the 8th, it's simply, Judge, we're ready to go. If we're reached for trial, then yes, you can appear virtually. But just talk with Ms. Rios about it. She'll remind me of that. And I will say that's okay again. Okay, how did you get here? Okay, all right. We will work for a virtual appearance if it's just a status report, okay? All right, Ms. Rios, anything else on behalf of Ms. Scott? Ms. Clark?
No, Your Honor.
Thank you.
Your Honor, may I be confused?
Yep. All right, so I think all that's left is Mr. Hill, but he is chatting with his lawyer.
She's gonna be kicked out. Yeah. Nothing. All right. So. Okay. But I have an announcement.
All right, Mr. Hill?
Yes.
Hey, Mr. Hill.
So this is going to be a negotiated plea. However, it's not going to happen today.
Okay.
It will happen on the 8th. It's going to be an in custody plea. Mr. Hill helps take care of some family members who are disabled, so this gives him time to, he also has a job, so this gives him time to get his affairs in order. And he's spoken to Ms. Dilligard as well, and she's okay with that.
Mr. Hill spoke with Ms. Dilligard.
Yes.
Okay, got it. Okay, that's helpful. So Mr. Hill, what I heard Ms. Wood say is that you're prepared to resolve the case, but because part of the consequence of these charges will be that you go into custody for a little while, you're asking, understandably, for some time to get your affairs in order. That's the generic term we mean, but you're caring for family members, you've got a job, and it's hard to just flip the switch. Query, Ms. Wood, if you think it makes more sense to take the plea today, so everyone knows what's happened, and he's entered his plea, which he can't step back from, and then if he can know what the sentence is going to be, assuming he shows up on the 8th. And that can just be his reporting date. And if he doesn't show up on the 8th, there's a different sentence. I'm not trying to switch things up. That just might, it gives me more comfort that we know what's going to happen on the 8th. But I'm just throwing that out there as a possibility where Mr. Hill would leave here today with family and do what he needs to do. He needs to be back on the 8th, but we actually don't even need to do much. He shows up, he basically turning himself in. You want to talk about that? Does that mess things up?
No.
Okay. All right.
Okay. Hold on.
It's not changing the outcome. It's just we would take care of 99% of what we need to today to give everyone the certainty so that when you came on the 8th, I'd just sort of make eye contact with you. Deputy Gordon will get you in there, and that's it. The 8th is going to be a crazy day. There are going to be lots of other people pleading and this and that, and you sort of know what's coming. My preference is to not have you sitting there sweating saying, I know I'm going in there, because it looks a lot nicer through that door. And this way you're just showing up and going in. But I'm not requiring that. So your lawyer and the prosecutor are going to talk about it, and then they'll talk with you.
Judge, with course indulgence, Ms. Dilligard and I are gonna keep working on this one.
Okay.
And so I do expect it to be appealed.
Okay. I just thought I'd throw that out there. So, Mr. Hill, importantly, let me talk to you about your bond and the need for you to be here on the 8th. Gosh, it says in your bond order, no driving. Have you been able to do that? Oh, you have. There's your driver. Okay. I guess we'll keep that in play. It's only one more month we're talking about now. I understand why. I'm looking at what the charges are. That's kind of draconian if you're working and taking care of people. It's not a critique of the judge who gave you that bond. It's just too bad. It might have been after 6 months. Had Ms. Wood had the case, she didn't have it then. She could have said, hey, could we modify the bond? And maybe he could just drive to work or something. Yes, sir.
Last time we did, we tried to speak, we spoke on a brief, just for that specific reason, because I did take them stop and work. So I didn't know, but it's just okay.
Okay. Well, there's only 1 month left. And so my thought is we're not going to change anything for that last month. Let's just, you figured out how to do it. I understand you figured out how to do it. So let's maintain the status quo. And you're staying away from whoever James Meadows is. So keep doing that. And then on the 8th, we'll do the plea and let it flow. Okay. Yes, sir.
Well, not times, but yeah, I go in.
You go into custody that day. My proposal was let's just do the plea now and then you turn yourself in on the 8th. We're just gonna do everything on the 8th. So you're gonna be sitting out there like everyone else. I'm gonna call the calendar and at some point we'll get to Cameron Hill. So like today, and Ms. Wood will say, Judge, that's a plea. And once we've called the whole calendar, that's one that maybe it'll be ready to go first. And so we can do it right off. I probably will just because I don't want you to get agitated, I don't know that I want to stay in this courtroom. And so we would probably prioritize your plea. And I will add this, if for whatever reason you all want to do this before the 8th because it's less crowded, on the 7th or something, we can do that. That means you're going in earlier. I'm not requiring that, but it could be a much more discreet event. It won't be in front of all these other people. But you and Ms. Wood can talk about that. And you may say, hey, look, by May 1, I'm good. I've taken care of what I need to. Could we find a day between May 1 and May 8th that's not on the 8th? Because the 8th is going to be real busy like it was here today. Okay? 8th will be the latest we do it.
Maybe earlier, but maybe get it knocked out.
There you go.
Thank you.
You're welcome. So I'll just write, will be a plea on this one. All right. I think that's it. Ms. Dilligard, you got anything else? Okay. Let's see. Ms. Jackson, thanks for hanging in there. Ms. Rivers, you both have a good day.
Thank you. You as well, Judge.
Thank you, Judge. You too.